Hey guys, good morning. Good morning. How is everybody this morning? Hey, replay crew. Love you guys. Today we are going to watch part 2 of Courtney Clenney's The OnlyFans model that unalived her boyfriend. We are going to watch part 2 of her stand your ground hearing. And hopefully it will go better than it went on Friday, because Friday StreamYard was just having a fit. They were just not cooperating. They weren't having it. I don't know what the deal was. I know now that I have extremely slow internet for live streaming that I didn't realize. So when I get done today, I will be calling and trying to get some faster internet. But it's not just my internet. I was told that some other YouTubers are looking into. Hey, Nancy. Um, hey, Judy. I'm sorry, I didn't say good morning to Judy. Hey, Judy. And everybody else, good morning. Good morning. So when I get done live streaming today, I will be calling and getting an appointment set up to get some faster internet. But other than that, oh, I did have something else to tell y'all. Hey, Robbie. I don't know if I told you guys, but the other day, if you don't know Florida weather is bizarre. In the winter, most days of the winter, there are some cold days, but mostly it's cold at night, cold early in the morning, and then it warms up during the day to like 60, 70. And some people don't think that's cold. But when you're used to temperatures in the 90s, low hundreds, 60, 70, that's like jacket weather. I'm hot-natured though. So usually I go short sleeves year round. Anyway, it was cold the other morning. It was like in the 50s. So we had the heat on overnight because it was like in the 40s overnight. So we had the heat on. And I was getting like really warm and really uncomfortable during the day because it should have kicked off, right? The heat should have kicked off. So I went and looked at the thermostat and it was 80. And I'm like, why is it 80 degrees in my house? No wonder I'm hot. So the heat had kicked off, but it was cooler outside than it was in the house. So I turned the AC on. And then, like an hour later, it's still 80 in my house. And I was like, wait, I don't think the heat kicked off. Because I kept hearing it kick in, but I had it on AC, but it was still 80 degrees. I'm like, I don't know what's going on because I'm hearing something turn on. I'm like, what is happening? So when Travis got home from work, he walks in the door and he's like, dang, what is happening? It's hotter in here than it is outside. I'm like, I know. I turned off the heat. I turned on the AC. It's still 80 degrees in here. I don't know what's going on. So he messed with it and messed with it and messed with it. I'm like, Travis, it's still running. Something is still running. I don't know what's going on. Finally, he turns off the breaker. So he turns off the breaker. He opens windows. It finally cools down in the house. So I don't know how many days he's just obsessing over the air conditioning. And he's mumbling to himself all day long. I wonder how much it's going to cost. We need to get a new air conditioner. That's an old air conditioning. That's been here for 30 years. We need, well, I guess I can call Aiken's Air Conditioning, or I can just go buy a unit, but I have the money now. If it's under $1,000, I have the money in savings. I can go get a new. And like, this is like days of this muttering under his breath about this damn air conditioner. And he treats, I mean, my husband, you guys know my husband is the best, right? Because I talk about all the wonderful, awesome things he does for me. But in instances like this, I become his secretary. So I'm sitting there. We went to Gainesville shopping. It's just like a 45-minute drive. On this 45-minute drive, all the way into Gainesville, I hear this muttering about this air conditioner. And I'm just sitting there praying, Lord, please let him do this by himself this time. Please don't let him make me call 50 different places about this air conditioner. So finally, last night, he's like, get on your new iPad and compare air conditioning prices for me. I was like, oh my God. So finally, he says, fine. Well, we found an air conditioning unit that he has the money already to pay for. I'm making a very short story long. I'm sorry. So, we found a unit, and then he's like, okay, now get on there to Aikens and find out if we get that unit, if they will put it in. And I said, honey, I don't know that air conditioning places will put a new unit in if you buy it. I said, and we might not need a whole unit. If it's just the fan, the last time they came out and they just fixed the fan. And he said, yeah, but they said that it was an old unit, and they would probably need to replace the whole unit next time. And I said, okay, wait, this is what I'm going to do. So I had to take over the whole project. I said, this is what I'm going to do. I went to their website, and it had like a little thing to send them a message. I said, I'm going to send them a message. So I sent them a message saying that they had come out and fixed the fan before, that it's over 30 years old, and I didn't know if the whole thing needed to be replaced or just the fan needed to be fixed. Could you please come out and take a look at it and let us know? And I put Travis's phone number on there. Okay, so here's the part I need to tell you guys. Travis called me a little while ago. They called him. They will be out here today sometime. I just don't know when. So hopefully, fingers crossed, StreamYard will behave. So if the guy from the air conditioning place comes out, I'm gonna have to go let him in, take him back to the air conditioner, and I don't know how long I'll be away from the computer. So I don't know what you guys want to do. If it crashes while I'm with the air conditioner guy, if you want to bail on me, I completely understand. But I promised you guys we were doing this today. And you know I keep my promises to my best of my ability. So we're going to try this, okay? But I just wanted to let you know, if I have to step away, it's because we got to get our air conditioner fixed. Because the last time this happened, it was June. This is the perfect time of the year for air conditioning in Florida to go down. Because we want to get this taken care of now before it gets hot again. So, okay, Nancy. Okay, so OnlyFans, Stand Your Ground, Part 2. Oh, come on, StreamYard, it won't even put it on the screen. Don't start. I haven't even started. Put it on the screen. Crying out loud. It's trying to do it. Right out of the gate. I am not believing this. Oh, there it is. See, I didn't the it looked like it was going fine, but it said that it kept little pop down thing kept saying that the page was unresponsive, not frozen, unresponsive. I didn't even notice that you guys were still talking to me because the chat on StreamYard was frozen, but the chat on YouTube was still going. And I looked over here and I was like, oh, they're still talking to me. Oh man. I like StreamYard. I think what happened, because they added some stuff. They added some nice stuff. When I guess whenever they changed ownership, they added stuff, and maybe that's why my internet is too slow for it now. Because it used to work fine. Wait a minute. Oh, I went too far. Her dad is on the witness stand? Why? This is going to drive me crazy. Maybe if I call them today, they can come out and give me new internet today. Okay, third time's a charm. Shadow, did you do anything in your room? You just want the door open, don't you?
Yes, Judge. Sean Appioff and Kathleen Hogue on behalf of the state.
Sabrina Puglisi and Frank Prieto on behalf of Courtney Clenney, who is present before the court.
Good afternoon, ma'am. So to answer your question, Judge, in regards to the medical examiner, he'll be here at 2 o'clock. I believe we're going to allow for defense to go out of turn and call a witness beforehand. And there are a couple of items from a discovery standpoint I don't believe anybody's objecting to that we will probably move into evidence and publish to your honor.
And Judge, here are the bank records, which will be addressed with Mr. Clenney. This is the copy for the court.
And I've had an opportunity to review them. I don't have an objection to them.
Do you have an objection to the recorded statement and the,
I know it's out of my control, but I feel like
No,
it
Judge. For purpose of Arthur, it certainly can come in.
so we'll go ahead and allow.
I'm embarrassed of what it is. It's embarrassing.
So then we're going to go ahead and start with
Mr. Kim Clenney. Mr. Clenney?
What was he like her? I thought Christian was her like business manager. I mean, I know he's not there, obviously, or we wouldn't even be having the hearing. But why does her dad get to talk about financial records? Yes, Nancy, that's her dad. His name is Kim. And I got confused thinking that Kim was her sister, but because I forgot that Kim can also be a guy's name. There's a director. He's dead now. He died of from cancer. His name was Kim Manners, and he was crew. I don't know if he wrote or just directed on two of my favorite television shows, my all-time favorites, X-Files and Supernatural. Of all TV shows ever made, those are my two favorite. Well, with the exception of Star Trek. Star Trek is hugely my favorite. But of TV shows that have come and gone, X-Files and Supernatural are my two favorites. And his name was Kim Manners. So I forget, because you don't hear a lot of Kims that are guys. So I automatically went to, oh, Kim, that must be her sister, but it's not, it's her dad.
One of our kind of dorm accounts, and then safeguard that way. And then as she needed it, we could use it on her benefit. Been traumatized for quite some time, but especially after April 3rd. And then she was drinking heavily.
Okay. And so with the drinking heavily and the traumatization, you felt that she could not adequately take care of her finances?
Yes.
Yes. Okay. So to your knowledge,
Started drinking
how many
after.
bank accounts did Courtney have?
At Bank of America, she had 3. One had a 0 balance when I accessed them. And
About those transfers that were made to you. The first transfer, do you recall when that was?
Oh, on StreamYard.
my notes.
Yes, you may. Does it seem like the
Okay, I am going to stop my camera this time because I remember on Friday it seemed to work better with my camera off. So we're going to try that this time.
to the amount in the Wells Fargo, let's just go back to the Bank of America. Once those transfers were made, how much money was left in those Bank of America accounts?
Refer to the notes again.
Yes.
In the account ending in 2923, the balance after the wires was $4,839.24. The account ending in 1712, there was $466.88.
And can you tell us the total of those two numbers?
The total of those two numbers, a little over $5,300.
Okay. Let me take a look because I think my math is a little bit different. Judge, may I approach Mr. Clenney?
I'm showing you the document from Defense Exhibit V. I believe, Judge, is it V that was introduced for the records? Thank you. I'm showing you this document, and
Right.
do you see that document?
Sorry, I misunderstood the question. I was giving you the balance the days after the wire. The balance you're asking about is what's in those accounts now.
Yes, yes, I apologize. So let me go back then.
Okay.
At that time, when the transfer was made, you're saying there was approximately about 4,000 in there?
There was approximately $4,800 in the 2923 account and $466 and change in the account ending 1712.
Okay,
That was after the wires. The balance that you asked about is today's balance. And that total for those two accounts is $11,278.55.
okay, perfect. So let's now go back to the accounts that you have. Those are Wells Fargo accounts?
Yes.
And whose name is that account in?
The personal, one of the accounts is personal account is in my name and my last name.
At the time that the wires, the first wire came in, what was the balance in that account?
It was $12 and
I'm
change.
doing this much, Tommy.
It was a dormant account. We really didn't use anything. There were a couple of drafts. And so I transferred money in as I needed to cover the drafts. But we really didn't use that account. So that's why I segregated it for Courtney.
So the three balances that were transferred in that you mentioned, it totals $1,184,000. Is that
Yes,
accurate?
That's accurate.
Yesterday, the detective testified to believing over $2 million was transferred or belonged to Ms. Clenney. Do you have any information that there was over $2 million?
No, he was incorrect.
And how do you know that it was $1,184,000
Because
only?
I did all the transfers and I was the only one accessing the account. And I have the bank records from
Now,
both banks, by the way.
let's talk about the expenditures that were made
Okay.
from that $1,184,000. I know there's many, but let's just start with, let's say, big expenses done.
So I wanted to take control of the account because I needed CPA to finish her income taxes. And so that was the first big expense. And I got a cashier's check. I was the purchaser, but she was the remitter. And it was for $335,818.
And Judge, I would refer you to Defense Exhibit O, which is a cashier's check and $305,018 to the IRS. On this check, who is the purchaser of the cashier's check?
I was the purchaser,
And who is the remitter?
Courtney Clenney.
And why did you make Courtney Clenney the remitter?
It was her fund. The next big expense, she wanted to move home, put down roots again, be close to us again. So she decided to buy a house.
Okay.
Yeah.
And this house is located close to you?
She had a contract on the other side of town, and then another house came available closer to us. And so then she put it off on that house.
And how much was the purchase price of the home?
And the purchase price was $1.35 million.
And what was the amount that was paid into as far as closing costs and escrow?
Those are my notes.
Yeah, please.
I know the number, but The first check on May 17th was for $21,000, and that was $20,000 escrow for their first house and a $1,000 non-refundable option fee. Then and I was the purchaser, but she was the remitter, and there's a copy of the cashier's check, so I know that to be accurate. The second cashier's check was for $10,000 additional when she put the offer on the new house, and so the $20,000 for the
She
first
thought
house
she was just
transferred
going to go
over, so
home
she
and
had
live with mommy and
$30,000
daddy.
escrow. The $10,000 was a cashier's check purchase on May 24th of this year. Again, she was the remitter and I was the purchaser.
And how much was paid into the home?
At closing, again, I went to Wells Fargo and got a cashier's check on dated June 16th. It was for $356,226.45. Again, I was the purchaser and she was the remitter.
And Judge, at this time, I would refer the court to Defendant's Exhibit N, which are two checks, one for $21,000 and one for $10,000, and a additional exhibit for a cashier's check in the amount of $356,226.45. Let me ask you this. What makes you qualified to handle the finances of Courtney?
I have a finance degree and I spent 15 years as an investment advisor.
Now, you said this account was yours. You didn't use it much, but did you mix your money with Courtney's money?
It was in the same account, but I segregated it on the ledger that I kept. I would print out the bank statements each month. And if there was anything that came out like a bank draft for my purposes, I would true it up. So her money was always what it should be.
And how did you distinguish her money when you say true up? How did you distinguish her money from your money?
I would go in and add each month if there were any, there was a loan payment that came out of that account.
I'm sorry.
There was a loan payment for me that came out of that account. And so at the end of the month, I would make sure what was attributable to me, I added up, and then I would either add back in to her money or I would have to deduct it if she owed me anything.
Were there any costs associated with Courtney moving from Miami back home to Texas?
Yes.
Can you describe that?
Now, run this again.
Yes.
There were two major expenditures, but there were multiple expenditures in those two areas. The first was moving out of the condo, the liquidated rent, cleaning, painting, things like that for the condo, attorney's fees. That was $26,885. And then there was reimbursement.
I'm sorry, can you say the exact amount again?
$26,885. And then there was reimbursement to me for hotels and travel as far as, movers, rental for the truck, things like that.
Baloney.
That was
Dad for
$30,074.
crap.
Now, did a large portion of the funds belonging to Courtney go to her defense of this case?
Yes.
She also went to rehab at some point?
Yes.
And how much was that?
The airfare and the rehab itself totaled $35,497.
Now, I'm sure that's not all the expenditures. Can you just give a general description of some of the other items?
There was
I don't understand why this matters.
$15,702 that went to some mortgage payments for the new house. Then she bought some assorted furniture, $12,072. And then there were some significant veterinarian bills, and that was $5,008. And beyond that, then you have the normal living expenses, daily living expenses, and then normal household expenses, electricity, utilities, things like that.
Now, at some point, a second Wells Fargo account was opened. It's ending in 4557.
I hate
Can
Wells
you
Fargo. They
explain
need to
what the
know.
purpose of opening that account was for?
Yes. So when Courtney was going to go to Hawaii for rehab, and so she was using my wife's debit card. So if we went to go get expenses for her that were related strictly for her, we would use the debit card related to that account, so we were using her money. When she went to Hawaii, she was concerned if she lost a debit card or somebody took it, she was concerned about the bulk
Yeah,
of the
it's
money being
digital.
in the
It's
first Wells
all
Fargo
digital
account.
transfer.
So she asked me, Dad, can you transfer it? Well, I didn't really want to transfer it to another one of my accounts. So I opened a Prime account at Wells Fargo and transferred the bulk of the money over there. And that way, if she needed it, I could transfer it back in, which I subsequently did.
Now, was that Prime account though in Courtney's name or in your
It
name?
was in my name only.
Was any of the money in that Prime account belong to you?
No, it was a brand new account. I never put any money in there.
And what is the balance in that second account, the 4557 account as of today?
The Prime account, zero.
And how do you know it's zero? When's the last time you checked the balance?
Yesterday.
And what is the balance in the 4926 account? That's the other Wells Fargo
I have
account.
to look at my note. It is- And this is as of yesterday, $126.65.
Okay. And so adding that to the two Bank of America account balances that Courtney has, it appears to be $11,405.20 total.
That sounds correct.
Okay. Do you have any knowledge of any other assets that Courtney has, such as stocks or bonds, other homes, boats, cars?
She has nothing other than the house.
And obviously she has equity in that home. She just purchased it.
Correct.
How much equity, if you have an estimate?
350 to 375,000.
So as far as cash value, to your knowledge, Courtney has $11,400.
That's correct.
Okay. May I have a moment, Judge? I have nothing further. Pass the witness.
Does anybody understand why the financial stuff matters? I'm confused. See, this is why I originally didn't want to stream trials, because I don't understand the purpose of some of the questions. I'm still gonna live stream. I like doing it, but I get frustrated when I don't understand, because this is transactions after she killed him. Is this supposed
Good
to
afternoon.
prove?
So you
What?
told us that you
We
are
weren't
Ms. Clenney's
married.
father,
That's
right?
correct.
And, obviously you have a very familial relationship with her. You don't want to see anything bad happen to her.
That's correct.
You would do anything for her as well as look over her finances, but if it came to it, you would lie for her.
No, I would not. I resent that accusation.
It's not an accusation.
It is an accusation.
Ooh.
I'm not trying to. Sir.
Oh,
But my question to you is, if it came to it, would you lie for your daughter?
No.
Okay. And in regards to her working situation, you know that she worked for OnlyFans. You know that because you're in charge of her finances.
Correct.
And you actually just said that you were talking about the first charge, the first expenditure, you did her taxes for her.
Yeah. Well, I didn't do the taxes. The CPA did the taxes.
You collected the documents to give to him.
Correct.
Okay. So in regards to OnlyFans, that's something that can be done online.
if you get a
Yes.
And
W-2
that's a
form
job
from
that can
OnlyFans,
be, if you have any internet access, it can be completed from that internet access.
That would be true if it wasn't canceled by OnlyFans.
Well, my question to you though is, as a result of how the company actually works, if you have an internet connection, you could theoretically use it.
I don't know how the company works. I just know that they are on the internet. That's all I know about OnlyFans.
You know that her videos are online?
I do.
Okay. She's not working now, obviously.
That's correct.
But if she got out, there's nothing stopping her from trying to continue to work for OnlyFans.
They've canceled her account.
Correct, right now. But nothing stops her from trying to reestablish that.
Well, I was told by her manager they weren't going to open her account.
Why, if he's found
I want to talk to you about
but not guilty?
the transfers themselves, but I want to start with, there's a letter that's in evidence that you wrote to the complex that she was living at down here in Miami.
Right,
That's dated, I believe, April 28th.
probably.
Was Courtney already out of Miami by that time?
Yes,
You know when she had moved back to, and I'm suggesting now, but you tell me, did she move back to Texas?
yes,
She moved in with you.
yes,
And prior to her going to the rehab center in Hawaii, she was living with you.
yes.
In regards to those transfers that were done, first, the two that were done on April 12th and two separate transfers, and then on May 3rd, did she do those transfers herself?
No, I did them.
You did them for her.
Yes,
Did she know that you were doing them?
yes, she did.
And you told us already that you have the importance of keeping accurate records.
I did.
You also know the importance of, in wires, labeling what the purpose of them are for. Is that correct?
Well, I don't think I labeled them.
You don't think you labeled them.
I don't recall labeling them.
If I showed you the transfers, would it refresh your recollection?
Sure.
Your Honor, permission to approach? Mr. Clenney, I'm directing you to these transfers. Are you able to see what they are labeled under the section origin to BENEINSTR?
Repayment of loans.
And so you see that you've labeled all three of them repayment of loans.
It was just an error.
So, sir, you say it's an error, but now you've also told us that it's important to keep accurate documents. Is that right?
Correct.
So now what you've told us today is, the purpose of this was for you to be in charge of your finances.
Right.
However, back on that day, you
Yes.
labeled those wires repayment of loans.
Right. Well, some of them were going to be all total repayment of loans, but then she needed money.
That doesn't answer my question, sir. You've labeled them two different things, one different here, one different on the day you made the transfers.
Right.
Are you lying then or are you lying now?
I'm not lying. It was an error on my part.
And now I want to talk to you about the defendant in her time in living with you. So during her teen years, did she live with you?
Yes.
Were there any incidents where either she was a danger to herself or to your family?
No.
Is there anything, so do you have any memory of any incidents of you being called out to a scene?
Judge, objection, this is beyond the scope.
Phase two.
It is.
Maybe we could stop our.
It's absolutely beautiful because they're just talking about finances. They're not talking about anything with the teenagers. Oh, yeah, Judy. I'm not good with the tax stuff. That's kind of what I meant. This documentation that says that she was given money because she worked for over here. But yeah. What, Spike? No, I'm not going back to bed. I tucked you in and you got back out. I'm not going to bed with you. I'll go tuck you in again. Anybody want a beagle? Come on. I give him 5 minutes. He'll be back out here at my feet again. We took down the Christmas tree yesterday. Shadow, can you guys see that? Shadow is pretending that it's still there. We were literally putting up ornaments in their boxes when she did that. That's where the Christmas tree was. She was very upset with us for putting the tree away. He does want to snuggle. I know. He's so sweet, but I can't right now. What are they doing? A sidebar? Why? Get why they do sidebars in hearings. There's no jury there. They don't want the witnesses to hear what they're saying. Tempting fate.
So, Mr. Clenney, if given the opportunity that your daughter is released, would she come back to live with you?
That's an option, yes.
And do you find her to be a danger to you?
Absolutely not.
Do you find her to be a danger to your daughter, your other daughter,
No.
or your
No.
wife?
No.
And are there any situations that you've had between, or that you've seen, that you've observed or been privy to between Miss Clenney and your wife and your other daughter?
I think she'd be a danger to another
I think,
friend.
well, no, because I think there may have been an incident that I wasn't there. So
Did you eventually learn of what happened?
I think the sheriff's office may have been called, but she wasn't a danger to those two people.
Do you know why nothing was done further?
Judge, I'm going to object.
And now you've been in the room for at least seen her the allegation and just
Oh, I had to show you guys a picture. Okay, no more camera.
But whether you know it to be true, you were in the court and heard it.
I did hear it, yes.
And then and also in January 30th through February 1st, the state's allegations that your daughter,
I did hear that.
and then the February 21st incident in the elevator.
Well, it's obvious that she's under duress, and we don't know what happened before or after.
My question to you is, you heard about it yesterday.
I heard about it the day before yesterday.
The day before yesterday. And then in regards to March, the multiple conversations between your daughter and the defendant where she called.
In what context?
Certainly, I'm not asking you that. So, and then obviously the incident that took place, the date of the incident, when the defendant killed the victim. You heard about that 2 days ago.
Well, when the defendant acted in self-defense, I heard about that, yes.
So after hearing those incidents that the state has brought to your attention in the last 2 days, you still feel comfortable allowing her to come home to your house, that you believe you can control her?
1,000%. No doubt.
Come on, Your Honor. Judge, I have no further questions. I would just move in those two documents.
Thank you. Mr. Clenney, are you aware of any banking regulations that say that you must, in the memo line, put exactly what a transfer is for?
I'm not aware of any.
And you testified that it was an error by putting in the memo line that it was a payment of a loan?
Right. So the if I put that in there, there was a sizable loan to Courtney, and that would have been the payment. But one of those wouldn't have covered that. So that's why I've been on the larger. If I'd had any notes to that, that's why that would have been put there. But I don't recall that.
The money that was transferred into that account from Courtney, whose money does that belong to?
That's Courtney's money, and I've spent it all on her behalf.
And did you do it with her permission?
Yes.
Now, the state attorney said, you know, you've been sitting here in this courtroom on the other day, you've heard all these allegations that were made, and he asked you if you feel comfortable having Courtney come home with you. Is that right?
I do.
And why do you feel comfortable?
Because I've lived with her a number of years growing up, and she was there 2 to 3 months with us this year. So I have no doubt that there wasn't any problems. I have no concern about that.
And did you have knowledge of the true relationship between Courtney and Abumseli?
Oh, yes.
And what was that?
Objection, Judge, as to relevance.
He opened the door, Judge.
Yes. It was
You did?
It was very toxic. And I knew from the beginning that he was not treating her correctly. I saw proof with my own eyes. I heard calls between them, calls to my wife. I heard many things that a father who loves his daughter very deeply should never have to put up with. So.
You know, that is one thing that I hate. I worked with a woman that she had 4 daughters. Every last one of them, three daughters. Every last one of them fight with a husband or a boyfriend. They would call their mom at work. What is she going to do? Number one, your parents can't help you with your relationship problems. Number two, she was at work. What was she going to do? All it did was drive her crazy because she couldn't do anything. And she just would talk to everybody. And we worked in a nursing home. So she would talk to the people in the nursing home about her daughter's problems. They don't want to hear about that. They're old old people at the end of their life just chilling in their nursing home. They don't want to hear about her kids' relationships problems. And I swear, this poor woman, she had high blood pressure and she ended up having a stroke in her early 50s. You think that might have been a correlation between the two things? Those girls drove her nuts. That is one thing I never did. Travis and I don't fight a lot at all. But the first year, there was a lot of fights. And I think that's just normal in a marriage, getting used to each other. But that's one thing I never did. I never went to my dad with any fight we ever had. He never went to his, well, he didn't have parents at the time. His dad died right after we got married, like the same month we got married. But he never went to his stepmom about any fight we ever had. We never involved our parents in any of our fights because they can't do anything. Why are you going to call your parents when you're having a dispute with your significant other? All that does is make your parents not like them. So then when you make up, that's just going to make tension in the family. And that's stupid. I'm sorry. I will get off my soapbox now. But that is just one of my pet peeves. Don't drag your parents into your marital spats. It's stupid and it doesn't solve anything. It just makes things worse.
She didn't deserve what she put up with.
Thank you. I have no further questions.
Judge, I would just ask that those two documents, if we have a ruling as to, at least for purposes of impeachment at this point.
Well, they won't. Evidence isn't, the impeachment isn't everything to evidence, but, have you actually looked at the documents?
May I ask which document, Your Honor?
It's up to you.
No objection, Judge.
Yes, Judge. Judge, for the record, that would be states 1L for identification purposes, 5 states 1A for identification purposes. No, we're not going to come in.
1L will become State Exhibit 11. 1K will become State Exhibit 12.
So, we can go ahead and proceed with the
I believe so, Judge. So the state would call Dr. Hutchins to the stand.
He's ready. He's ready. He's got his right hand up there.
come up for just a moment. You guys want to go to the conference. George is saying that he made the defense that it's not labeled.
Oh, he's out.
On Tuesday.
The only one I have labeled are the ones you gave me today.
I don't know what I am.
You guys are
This,
referring to.
this was dropped off because we didn't have a package for the clerk on Tuesday. And we dropped them off that next day, the next morning at the clerk's office. So during the hearing, they were not being labeled by the clerk because we had forgot to bring a copy. But
These are the,
that was the list at that time, correct?
okay, and that's what you're going by when you're saying.
List was
Come on,
filed.
put it together.
I don't need that.
We can just go ahead and proceed with
Yeah,
it.
we can.
And I think even
You swear from the evidence.
Okay.
The truth, the whole truth, nothing but the truth, so help you God?
Yes.
Good afternoon, Dr. Hutchins.
Afternoon.
Thank you for coming back today. Could you please introduce yourself to the court?
My name is Kenneth Hutchins. I'm the Chief Medical Examiner for the Miami-Dade County Medical Examiner Department.
And just for the record, are we able to hear him?
Yeah, hello.
Okay. So, Dr. Hutchins, where are you currently employed and what is your current position?
I'm employed by the Miami-Dade County Medical Examiner Department, and I'm currently the Chief Medical Examiner.
And how long have you been working there?
About 21 years,
And how long have you been the chief medical examiner?
a little over 1 year.
And so were you in that position at the time of this case coming in?
Yes,
Now, is this your office? Is it an accredited office?
yes.
And what does it mean to be an accredited medical examiner's office?
It means that we have standards that we meet for the National Association of Medical Examiners.
And could you please explain to the court some of your background in becoming a medical examiner?
I received my BA in biology from Swarthmore College, my MD from the University of Pennsylvania School of Medicine. I did a pathology residency and neuropathology fellowship at the Albert Einstein College of Medicine in New York. I did my forensic pathology fellowship and training at the Office of the Chief Medical Examiner in Baltimore.
Yes, Your Honor, we so stipulate.
So
Yay.
I'm going to bring you and your focus to this matter, to this case. And so the case, were you assigned to ME case number 2022-1069?
Yes,
I'm showing you what's in evidence that states Exhibit 2. Do you recognize it?
yes. I'm Boselli.
If you don't mind, can you please publish it to the court? Judge, if you don't mind, if you could just keep that up there. Thank you. And just for the record, Judge, I'm showing defense. the photographs. Now, evidence of medical intervention.
Yes,
And what exactly was that?
I'd have to review the medical examiner report to let you know.
If you don't mind just taking a moment.
He had a lot of medical intervention, including an endotracheal tube protruding from his mouth, a catheter in his left groin, vascular catheter, a urinary catheter from his urethra, a 21 centimeter transversely oriented sutured left thoracotomy incision. The pericardial sac was open. The sac around the heart was open. There was 200 milliliters of blood in the left chest cavity. There's a chest tube protruding from the right chest. And he had multiple needle puncture marks on the upper aspect of the left chest associated with some subcutaneous hemorrhage.
And now in regards to the wound itself.
Okay, that's interesting to me because when I worked in the hospital, I worked on the pediatric floor. So, we did have patients that died on the pediatric floor. But usually, when they got sicker, they would go to the pediatric intensive care. So, I don't have the experience of having a hospital patient die, but I have a lot of experience with elderly patients dying from when I worked in a nursing home. And like he's saying, all these things were still in place, all these tubes were still in place in his body. When someone dies in a nursing home, you take all those tubes out before they get transferred to wherever they're going to get transferred to. Because usually with an elderly person, they don't get an autopsy because, they're old. You know why they died. So they go right to the funeral home usually. So all those tubes are gone. So I just found that interesting from a medical standpoint. So just a throwaway comment, but I just found it interesting.
Was it a singular wound?
Yes,
Now I'm showing you States Exhibit 3 and States Exhibit, I believe, 9. No, it's not going to be 9. States Exhibit 3 and States Exhibit 4. First, States Exhibit 3. Do you recognize this?
yes.
What is this a photograph of?
This is a photograph of the sutured wound in the upper left chest.
And is it the same condition that you saw that day?
Yes,
Please publish it to the court. Now, at some point in time, did you remove the sutures?
yes,
And what was the purpose of that?
to get a better idea of what the wound looked like.
And I'm showing you States Exhibit 4. Am I taking a look at that? Is that how the wound looked after you removed the sutures?
I want to
Yes.
see it.
You also publish that to the court.
I know they're not going to show it, but I want to see it.
I'm also going to show you States Exhibit 6 as well as States Exhibit 5. Is this a closer, and that's States Exhibit 5, is that a closer image of that wound?
Yes.
And how exactly would you describe the wound?
It's a sharp force injury wound that has nice, clean, sharp margins. It's extended open. It was 4.4 centimeters in length with the sutures in it. And when the sutures are removed, it's 4 by 1.5 centimeters. There's a lot of hemorrhage beneath it, and there's no contusion or abrasion around it. So that suggests that it's a sharp force injury and not some other type of injury.
And is it consistent with what you would see with a knife injury?
Yes.
You could also publish 5 and 6 to the court.
Oh, the front knife injury, though, that's a stab wound. Yes, this is my opinion. I suppose I have to say that.
Now, something that I do believe may come up by defense, are you a knife throwing expert?
No, I'm not.
Are you an expert of someone or what knives would do to people?
Yes, I am.
So in regards to the wound itself, what type of injury did that knife wound lead to?
It went down into the soft tissue and through the muscle and injured the right subclavian artery.
Now I'm showing you State's Exhibit 9. And what does this photograph show?
This photograph shows that after the skin is removed from the where the injury is, the hemorrhage around the injury, and the injury in the right subclavian artery.
If you don't mind me, I'm going to hold it up for you. If you could point exactly to where the injury is for the court.
The artery is here, and the injury is right here in the artery.
If you could publish this to the court. And now I'm showing you State's Exhibit 1. Do you recognize this?
Yes.
What is this?
This is a picture of the artery after I removed it from the body.
And I'm going to hold it up. If you could please explain to the court exactly what you can see on this one.
This is the inside of the artery after it's open, and there's a hemorrhage around the injury in the artery.
You can publish that. Thank you.
I didn't know they had to remove the artery to inspect it.
Now, Dr. Hutchins, if you could explain, was this a stab wound or an incision wound?
A stab wound.
And what are the differences?
Well, in general, an incised wound is longer on the skin than it goes into the body. A stab wound is measured shorter on the outside of the skin than it goes into the body.
And in regards to this wound specifically being a stab wound, how far into the body did it go?
Approximately 8 centimeters.
Now, when we talk about 8 centimeters, is that more than 3 inches?
Around that.
Can you explain to the court exactly what occurs when someone is stabbed in, say, specifically the subclavian artery?
Bleeding.
How do you stop the bleeding?
You'd have to go to a hospital and they would stop the bleeding. I don't really treat live people, so I can't be more specific than that, but you go to the hospital and they will treat you.
Dude, you went to
So
medical
the
school.
importance is if you're not able to stop it though, bleed.
Yes.
Can you die if you're not treated medically?
Yes.
Duh, that's why we're
Now,
here.
could you explain exactly the location of the wound?
The wound is on the right side of the chest, 13 inches below the top of the head and 6 inches to the right of the midline of the front of the body.
And now this wound specifically, did it have to penetrate muscle?
Yes.
And how much force specifically would be needed to say breaking the skin for a wound like this?
Well, people have done experiments to see how much force it takes for a knife to go into different parts of the body. If the point of the knife is sharp, it takes between 8 to 12 pounds to get through the skin.
She did not do that.
And now we had talked already about the sutures. The fact that they added sutures to this wound, did that do anything to change the depth of this wound?
I honestly don't know what they did with this wound. If all they did was suture it, it would not change the depth of the wound, no.
And now this trajectory, in regards to the trajectory of this wound specifically, what is the trajectory?
It's front to back and slightly downward.
Is that consistent with the knife coming downwards?
Yes.
Now, there's a couple of other items I want to talk to you about that's a part of your report. Toxicology specifically that was done on the victim. Were there any substances present?
The prosecutor, no.
What
He had,
was present?
Cannabinoid.
well,
Would that have any effect on the stab wound?
No.
In regards to, I think you also wrote in there something about cardiomegaly. Could you
Yes.
explain exactly about that exactly?
It's an enlarged heart. His heart was 470 grams, I believe.
actually,
So
I think
it's an enlarged heart, but he was a big guy. And if you're a person that exercises a lot, you stimulate your heart and it can become large.
And would that have anything to do with this stab wound?
No.
Other than that, is the victim in good health?
Yes.
Now, what information were you provided in this case?
I was provided information from our investigations report, and we have a preliminary death investigation report for the medical examiner from the police as well.
If you don't mind informing the court, what information did you have in regards to how the victim received this wound?
I'd have to read the report.
Your Honor, do you have any issue if you read from the report?
Sorry.
I'm gonna try to put that on the screen. I don't know if it's go, but it
Okay,
needs
you
to
can
be
read from the report if
seen.
you like.
Okay, it's a very long report, but I'll just say, it says, the offender in fear for her life warned the victim to stay away. The victim approached in an aggressive manner. The offender threw the knife and struck the victim on the top right chest area. The offender then called police and attempted to add pressure to the wound.
She'd have to be.
Based on that information, I want to pose to you a couple of hypotheticals, but the first and the last thing I want to show, Exhibit 8. If you could explain to the court exactly what this is showing.
I
Hold it up for you.
put probes in the artery and the vein. The probe came out of the artery. The probe went through the vein, so the vein was intact.
Is that to show also the trajectory of the wound?
No, this doesn't show the trajectory of the wound. The wound is going downward and from front to back. I have these just going in the arteries. They're going laterally from left to right.
Thank you. So going back to these hypotheticals, based on the information that you had in your observations, the position of the wound, the angle of the wound, the depth of the wound, does that support that the victim and the defendant were face to face when this happened?
As a hypothetical,
As a hypothetical.
yes.
And as another hypothetical, based on the same position, observations,
You had to
angle,
climb
the
up
depth,
on
does
something
it support that the victim was stabbed?
Yes.
because it was downward and she's shorter than
Based on those
him.
same observations, does it support that at least 8 to 12 pounds of force would have been used in order to create that damage?
In general, yes.
And that damage being breaking through the skin, plunging the knife 3 inches into the victim's chest and cutting through muscle, eventually the subclavian artery.
Yes.
Now, based on the information you received that the defendant was alleged to have thrown this knife, do your observations support that?
I'm not an expert in knife throwing. If the person who supposedly did this is an expert knife thrower, and the knife is the type of knife that you can throw, I guess that could have happened.
Did you receive any information that the defendant was a knife thrower?
No.
So based on that fact that you did not receive that information, would it support that?
No.
And what would you expect to see a knife do if someone just flung it at somebody?
Threw it the way a knife thrower throws it,
No, someone that's not a knife thrower.
it would just hit the body and bounce off.
Yep,
Now, as a result of this case,
100%.
did you come to a cause, or did you make a determination as to the cause and manner of death?
Yes.
Could you please explain those to the court?
The cause of death was stab wound of right subclavian artery. The manner of death was homicide.
All right, I have no further questions.
Death at the hands of another.
Good afternoon, doctor.
Afternoon.
Around what time did you receive the body for you to be able to perform your autopsy in this case?
I performed the autopsy at 9:30 a.m. I'm not sure when the body came to our office. I'd have to look through the paperwork to see.
That's okay. And 9:30 a.m. on April 4th,
Yes.
2022?
Yes.
And you understand that this incident took place on April 3rd, the day before?
Yes.
Okay, so the very next morning, you were already performing your autopsy.
Correct.
Conducting your autopsy, you first read and review that preliminary police death investigation report for the medical examiner?
If we have it, I do, yes.
Okay, and it's fair to say that you might not always have that, right?
Correct.
and that's because you have to wait to receive it from the detective in a case?
Yes,
So having that or not having that, that doesn't really affect your ability to get started on doing your autopsy.
not to get started, that's correct.
Do you know if in this case you had that report before you were able to start? Do you remember?
I don't have any independent record.
So you start your autopsy at 9:30, and before we get to exactly what you performed, well, let me just say this. There's a lot of paperwork that goes into all that you do, right? It's not
Yes.
just all your examination.
Yes,
There is a release of the body, eventually an authorization for that, right?
yes,
There are case notes that you do.
yes,
There's a forensic evidence form,
yes,
a death record, medical information sheet,
yes,
a microscopic report.
yes,
So lots of paperwork.
yes,
All right. First, before we go into what you actually performed, I want to go over this preliminary police death investigation report that you eventually received. And this is, fair to say, a tool to help you put some context to the situation. Is that fair to say?
sometimes, yes,
Because you clearly, obviously, you are not present for what happens that makes you receive the body, right?
yes, that's correct,
In any case, not just this case.
that's correct,
So you have the autopsy you perform, but having some of the information, some of the background can be useful to you in making your final opinion. Is that right?
yes,
Okay. Was that, according to what it says, that Ms. Clenney said she was arguing with the decedent, Abu Seli, when he grabbed her by the neck and slammed her onto the wall. Is that right?
yes,
She then says that he grabbed her, threw her on the ground, and held her down by the neck with both hands.
I don't have that in this report that I'm looking at, the police report.
It says the offender in fear for
Yes,
her
I see
life.
it now, you're correct,
The victim approached in an aggressive manner. Is that right?
yes,
And that is important information for you, right? Whether the person was stationary or moving could make a difference to you. Is that right?
it could, yes,
Okay. And we'll get more into that in a bit. But according to the report, the offender threw the knife and struck the decedent in the top right chest areas. Is that right?
yes,
And it also said that she called police and attempted to put pressure on the wound, right?
yes,
As far as blood loss, right?
yes, it could,
And we'll talk about that in a few moments. Now, your opinion was that this was homicide, and you put that in various portions of your reports. Is that right?
yes,
You would agree with me that a homicide could be justified, right?
yes.
Now, what happens in a situation if after your report or your autopsy, you determine that you do believe it was himself? Is a way that you document on your report?
That's a legal thing, we don't have anything to do with that,
Okay, so even if you homicide no matter what?
correct,
Okay. I'd like to talk about the social history. These are in the case notes, and I understand there was a Carlos Marmolejo that took the case notes. Is that somebody that works for your office, sir?
yes, it is, he's a medical legal death investigator, yes,
And in this case, they spoke with, according to the case notes, the aunt of Abu Seli in order to get some information. Is that right?
yes,
And some of that information could be useful to you, obviously, whether the person is healthy or not healthy, has a medical history, illnesses, that sort of thing, right?
Yes,
And one of the things that your office was advised was that he did not drink, smoke, or use illegal drugs. Is that correct?
yes, that's correct.
But in fact, when the toxicology came out, it let's talk about the estimation on time of death. Is it fair to say that you cannot with certainty state when the stab wound occurred in this case?
That's correct.
And obviously, one, you've already said you weren't present, right?
Yes,
But it's also very difficult because there are many variables that go into that. Is that right?
yes, that's true.
So, for example, as somebody is losing a lot of blood, it will have different physical effects on a person's body, correct?
Yes,
So in this case, the subclavian artery was hit. That is something that's going to lose a lot of blood, right?
yes,
And so when a person is losing a lot of blood, the various physical effects they may feel could be chills, right? They get cold,
they could, yes,
loss of feeling in their limbs.
yes.
They might have problems speaking
As they start to go into shock, maybe, yes,
and then lose consciousness.
yes,
And the rate of loss of blood can be affected by, for example, how big the person, their body type, right?
it could,
I not only have a problem with she threw the knife. If he had her down on the ground, he let her up. So she could, okay, I know Florida has the stand your ground law where if you're in your own home, you don't have a duty to retreat. Yeah, I get that. But if someone is attacking you and you're able to leave, what? Especially if it's somebody that you claim to love, are you going to pick up a knife and stab them? Or are you going to get out of there and get help? Or maybe that's just me. I don't know.
could be, yes.
What about if pressure was placed on the wound versus not placed on the wound?
Yes, that could affect the amount of blood that is lost.
And the usual progression of blood loss will be that the person might be speaking, then move to nonsensical speaking, then kind of just making kind of noises until they lose consciousness. Is that right?
That could be something that could occur, yes.
Now, did you listen to the 911 call in this case?
No,
Okay, are you aware that Mr. Albumselli, first of all, 911 was called at 4:58 p.m. Are you aware of that?
no,
Okay, and were you told by anybody that when 911 was called, he could be heard saying, "I can't feel my arms"?
no,
Okay, if you heard though, or you understood that information, that would appear that he wasn't at the point where he was at unconsciousness yet. Correct?
that's correct.
I don't know why people stay with people that treat them badly.
Now, time of death was called at 5:58 p.m.
I guess I can't say that because I was in an abusive relationship when I was young, but it wasn't physical. It was the same type of relationship that I had been in with my mom. It was controlling and coercive type stuff. which I thought that was normal because that's the way my mom treated me. I thought that's what love was. Thank God that relationship didn't culminate in marriage, because who knows what would have happened. It could have escalated to physical, and then I would have been stuck like Chuck. But so I guess I do kind of know. And then if you do marry somebody that's abusive, which is totally not this case, because she had her own money, she could have left, but there are cases where women marry somebody not knowing that they're abusive, and then they become abusive, and then they're cut off from family, they don't have any money, and then they can't leave. But this is not that case. She had broken up with him and kicked him out, and then they made up and he came back. But I don't see him as being the abuser. All these clips that have come up over the past couple of years of them fighting, it's been all her. Yeah, he's still speaking, so he's not unconscious yet. Yeah, some of these questions are pretty obvious. I mean, I know they have to lay a foundation, but sometimes these questions are like 5th grade questions. You know what I mean? Like, yes, if he's speaking,
Is that right?
I have it at 5:55 p.m.
You're correct. I apologize. 5:55 p.m.
Yes,
That the 911 was called at 4:58, and approximately 1 hour later is when time of death was called. Is that right?
yes.
I'd like to look to your autopsy protocol and dictation. This is really the substance of your examination, right? Your report?
Yes,
And the first thing you do is you conduct an external examination of the body.
yes,
And I understand here you would put no fractures, lacerations, or deformities of the extremities. Let me ask you this. Can you explain what the difference between a stab wound and a laceration is?
a laceration is a tear in the skin from a blunt force injury. So a blunt object hits the skin, it tears the skin. So when you look at the injury, there might be an abrasion or contusion around it because the skin was struck by a blunt object. It tears the skin, so you have tissue bridging going from one part of the skin to the other. These are small vessels that don't get torn when the blunt object strikes the skin. A sharp force injury cuts the skin. You don't get abrasion or contusion around it, and you don't have tissue bridging because those little vessels are cut.
Okay, so that's the difference of why you wouldn't call the stab wound to the chest a laceration?
Correct.
Okay. You did notice, though, that there was a healing scar surrounded by smaller healing scars on the right heel. Is that right?
Yes,
Okay. And the heel is considered the foot?
yes,
Okay. You didn't notice any healing scars on legs, did you?
Captain Obvious.
legs, no.
And you didn't notice any lacerations on the legs, is that right?
That's correct.
If you had, you would have documented, right? That's what this portion of your report is for?
Yes,
Now, the internal examination, I'm sorry, I didn't understand half of what you said of all the things you did. Obviously, I'm not a doctor, but there's a lot of things you have to do, right? You have to weigh the lungs and the spleens, and you do all these different tests, is that right?
yes,
And that's just normal protocol in any of these cases?
yes,
And you do that because obviously you want to make sure you do everything you possibly can in order to make a proper determination as to cause of death.
yes.
Now, your opinion in this case was that the wound was not caused by the throwing of a knife, correct?
I'm not an expert in knife throwing. I don't know Whether the person who's charged with this is a knife thrower, as a hypothetical, my opinion is it was a stab wound. But if you give me other information that the person is a knife thrower, they throw knives and they throw them into targets and whatnot, then maybe this could have been a knife that was thrown.
Okay, well, we're gonna break that down. Before we do, I want to ask you a couple of things. I know that you eventually, you did review this preliminary report, you said. Were there any other reports that you reviewed in this case? For example, the fire rescue report?
No, not that I recall.
Okay. Any other supplemental reports from the detective?
No,
Did you review Ms. Clenney's statement to the police?
no,
Would you agree that perhaps there could have been something in her statement, facts, important facts, that could maybe change your determination as to the outcome?
as the cause and manner of death?
As to, not the cause of the death, but as to that it wasn't by a knife being thrown?
Repeat the question again?
Is it possible that by reviewing her statement completely, it could possibly have changed your determination that a knife could not have been thrown in this case?
It could have, yes.
So let's look to the evidence of the injury. That is another section in your report, right?
Yes,
Okay. And first of all, when you received the body, the wound was sutured, right?
yes,
And that's just normal because when the person goes to the hospital will do that and give it to you, or not necessarily?
not necessarily.
Okay. Is it fair to say by suturing it, it might change how you can observe the body in its, I guess, most natural form of when the incident occurred?
That's fair to say, yes.
And you don't know if, I mean, you weren't there, so you don't know what fire rescue personnel might have done, paramedics did for life-saving techniques, right?
That's correct.
And you don't know what kind of life-saving techniques the doctors at the hospital performed either, right?
That's correct.
So you received the body, you removed the sutures, and then you observed the stab wound, which I believe in your report and you testified is 4 by 1.5 centimeters, correct?
When I remove the sutures, yes.
Yes, and again, when you remove the sutures, we don't know if that wound is the same wound I don't mean the same wound. I mean, we don't know if it's the same size as when the stabbing originally occurred, right?
I don't know if the hospital physicians did something to the wound. That's correct.
Okay, and 4 by 1.5 centimeters, that would be equivalent to 1.5 inches by 1/2 inch? I did the mathematics. I'm just not a centimeter person, so I put it into inches.
I think an inch is like 2.5 centimeters. So you're talking more about 3 inches
Okay,
in length,
okay.
or 2 inches in length.
Well, the 8 centimeters, which is the depth of the wound, is 3 inches. So would you agree that the 4 centimeters is gonna be
It's
half of
short.
that?
That's
So 1.5 inches?
Do this kind of work.
probably, yeah.
Okay.
I'd have to do the math.
I understand. And
Don't let me do the
according
math.
to your report, you put that the wound, that it was a slightly downward angle, is that right?
Yes,
Now, I looked up the definition of slightly in the dictionary, but is there a medical term for slightly?
no,
Okay, so
Slightly,
I got
slightly,
small or
what the heck?
inconsequential. Does that sound
Oh,
fair to
boy.
say to you?
it just went down a little bit.
Just a little bit. And do you ever give percentages or
No.
that's not something?
No,
Okay, so you can't tell us exactly, I'm gonna say this in this downward angle. It's not a downward angle like this, right?
yes, that's
When you
correct.
say slightly, if we're taking something, it's gonna be just a slight angle.
Yes,
Okay. Now, agree that when a person, if somebody were standing face to face and stabbing somebody, would you agree that it would depend on the height of the individuals, of the two people?
The injury?
Well, potentially, how slight it goes in. It could be based upon the entry wound could depend upon the height differences of the two people.
When I describe wounds on the body, we're looking at the body in anatomic position, lying on the autopsy table. When something happens to a person, if they're shot or stabbed or beat, they don't stay in anatomic position. They move. So I can't tell you in what position the person during the stabbing was in and in what position the person being stabbed was in. They could have been bending over, they could have been bending back, they could have been on their knees. I don't know.
Okay, that's fair to say. So it would be clear that you don't know if, for example, Abu Mseli was leaning forward and going to aggressively attack Miss Clenney, right?
That's correct.
Which would then move his body forward and could affect the angle of how a knife goes into his body.
That's correct.
Also, the fact that she's 5'8" and he's 6 foot, which is a 4-inch difference, that's not something you're taking into consideration in your examination.
That's correct.
Now, the location of the wound was the upper chest right side.
Yes.
And that fair to say, like near the shoulder?
Yes.
Okay, and for the record, I'm pointing to my shoulder area on the right side. You noted that it was a front to back, which just means from the front of the person going inward towards the back, is
Yes.
that right?
Duh, what is her?
Now, and I'm assuming this is because of the anatomical position of the body, but you didn't mention if it was like at an angle coming crosswise or straight on. Was it straight on?
It was straight on, yes.
Okay, so if hypothetically Courtney is right-handed and the wound is on the right side and she did stab him versus throwing the knife, she would have had to have been offset from him to be able to put the knife straight into his right side, right?
It depends on how he's standing. If he's just standing in anatomic position, yes. If he's moving, I cannot tell you in what position the person who was stabbed was in or what position the person who was doing the stabbing was in. I can just tell you what I see on the body.
Okay. And in your report, you document that the wound is approximately 8 centimeters, which we said was 3 inches, right?
Yes.
It's about 3 inches.
We're going to call
You
her
understand that
attorney of
the knife was removed before the paramedics arrived? Did you know that information?
I did know that information. I did see a picture of the knife.
It was now
Okay. And let me ask you this, because if a person were to, and the testimony from Courtney was that Abu Mseli removed the knife himself. If a person is in shock from having been stabbed and they go to grab the knife, it is possible that the knife could be pushed in a little further. Would you agree with me?
I'd agree with that, yes.
And it would be impossible to know exactly, I mean, you couldn't give a certainty as to how much exactly it could be pushed in, right?
I can't know.
Well, that is a good point. I didn't think about that.
And
Throwing it.
obviously, if the knife is in and you pull it out and it was in an artery,
Yeah,
the
never.
blood can really start coming out, right?
Yeah. Yes.
Okay, medical advice, y'all. Don't ever pull a knife out. If you're stabbed with anything, don't ever pull it out. Wait until you get medical people there to you or you get to medical people. That's how Steve Irwin died. You guys remember the crocodile hunter? Wasn't that his name? His professional name, crocodile hunter. He got stabbed by a stingray, a type of stingray, a giant stingray. I forgot what kind it was. And the barb stayed in him, and they were out at sea, and he pulled it out. If he'd left the barb in until they could get him in and get help, he probably would have lived. But he pulled it out and he bled to death before they could get him help. So if you ever get stabbed with anything, well, I mean, not like a bee sting, but like stab with something, don't pull it out until you get help, because you will, if it's got an artery, you'll bleed to death. But if it's in it, it'll stop. It's like plugging a hole, you know what I mean? And you take it out, you unplug that hole, and then you bleed to death. And you might have already known that, but I'm a nurse, and I felt like that was an important thing that you needed to know. So.
Now, you mentioned that the pressure
That is terrifying, but yeah,
used
that's what you
to
got to do.
have the force to put a knife into a body would be 8 to 12 pounds to get through the skin. Is that fair statement of your testimony on direct?
People have done experiments on cadavers, putting knives through different parts of the body, cartilage, bone, skin, and they have described it as being 7 point something to 11.9 pounds to go through the skin. So 8 to 12, yes.
Now, knowing that this was in the subclavian artery, it didn't go through bone?
No,
Okay, so it went through muscle, and then the artery is right underneath the muscle?
subcutaneous tissue, muscle, and then the artery is down there, yes.
Okay, so you're not sure exactly how much pressure, but estimating based upon experiments, you think approximately 8 to 12 pounds.
Yes,
Now, that's quite a bit of pressure. Would you agree with that? That's not just like me standing here and just like straight putting a knife into somebody's body, right? You have to
you have
really
to push
put
it
some
in.
pressure.
Yes,
Okay. And would you agree with me that it would be more the pressure, the more you can move your hand back and move something, you're gonna get more force to it, right? Just like a baseball, if I'm throwing a ball, I'm gonna get more pressure and it's gonna fly farther than if I just hold it like this and just kind of throw it like that, right?
that's correct.
Okay.
I'm not
So
an expert.
did you see any defensive wounds on Mr. Abumseli?
No,
All right. Now, let me ask you this. On the autopsy dictation, if you want to refer to that, sir, it has height and weight. Can you tell me, I with your handwriting, I apologize.
Yeah, he's a doctor.
The weight,
Read it.
what does that say, sir?
Unless you want to sideways.
which form are you looking at?
It's called the autopsy dictation. If you
Oh, yeah,
you have it?
200.
Okay. That's a 2, that's a 0 and a 0. It looks like
Yes.
a 2.6.
No, it's 200
Okay, and what's the 2.7 underneath it?
is BMI.
BMI, okay. So 200. And if I told you that Courtney was 150, then the decedent Abumseli had 50 pounds on her. Is that
Yes.
right?
Yes,
And 4 inches.
yes.
And as you say, like, having to go back and pressure and everything like that, you didn't see anything from Abumseli of putting his hands up or anything like that?
I didn't see any defensive injuries on his arms or hands, no.
Okay, you would agree that somebody who is 6 foot tall has a farther reach than somebody who is 5'8"?
Depending on the length of their arms, yes.
Okay. Now, would you agree that it's also possible to, for somebody stabbing somebody, they could possibly have self-inflicted wounds? Isn't that possible?
Yes,
And that's because I think they call it slippage, right? Because of so much blood, the knife could slide back and it could cause cuts on the person's hand, right?
yes.
Okay.
I wish I'd done that before I became a nurse.
Sorry. Judge, if I can have a moment.
I went to nursing school with a woman that had been a paramedic, and she actually went back to being a paramedic after she got her nursing degree. Pay was better.
I'm showing you defendant's exhibit S. Sir, can you see that? All right, these hands?
Yes,
Okay, and were you able to see crime scene photos in this case? Were you able to observe did they give you the crime scene photos to look at?
I did see some crime scene photos, yes.
Okay, so this is a photo of Miss Clenney's hands on the date of the incident. She didn't have any kind of self-inflicted injuries from a knife that you can see. Is that fair to say? And I can have a photo come closer to you if it's easier for you, sir.
I'd like to see a closer
Yes,
photo.
let me, do you have S? Yeah, the ones from, yeah, thank you. Thank you. Having reviewed the photographs, were you able to see any wounds on her that would be consistent with slippage of a knife?
No,
Hold on, just wait 1 second. Oh, can you turn to the next one, please? Oh, here. Thank you. Now, you received photos of the knife. I think you said you
I
saw the
saw
knife?
photos of the knife, yes.
Okay. And from your examination of the wound, would you be able to say how sharp the knife was?
By just looking at the wound?
Yes.
No.
What about, you see this knife, this kitchen knife, can you tell how
That's a
thin
knife?
or thick the knife is
Where did
by
you
your
get the
examination?
By looking at the wound itself?
By looking at the wound, yes, sir?
No.
And what about by examining the knife itself?
You could, are you getting at whether I can tell whether that was the knife that did this particular thing?
Well, let's assume it is.
Okay.
If there's any
assume.
disagreement with that. So my question would be, if you had the knife to examine, would that help you in determining whether it is thin or thick or sharp? or
Yes.
dull? Now, you would agree that a knife that is thin is able to penetrate deeper into a body than one that is dull, right?
One that is sharp would be.
Yes, one that is sharp,
Yes,
excuse me.
yes.
But not just sharp, one that is thin versus thicker is what my question really was.
It depends on how sharp the knife is, not necessarily thin or thick.
Now, in this case, this is the Global Cromova stainless steel knife GS14. It's a very sharp and thin knife. Did you do any research into this knife before
No.
you made your determination?
No,
Did you get any information on the weight of the knife?
no,
You do understand that the weight of a knife can make a difference when it is thrown through the air, right?
I'm not an expert in knife
How
throwing.
many times? Oh my God, how many times did you have to say that, woman?
Are you aware that the distribution of the weight can make a difference on the rotation of the knife in the air as it
And it's
is
the same
thrown?
thing you just said. Objection.
As a novice in this particular thing, I would be aware of that, yes.
Okay. And are you aware the more a knife weighs, the deeper it can penetrate a body?
When throwing it,
Yes, sir.
that I don't know.
Would you agree with me that throwing a knife into a stationary object could be different than throwing a knife into a moving object?
Yes,
And that's because a knife throwing has velocity, and a person moving in that same direction has a certain velocity as well, right?
yes.
I don't think he's being uncooperative, Nancy. I think he
And
just
you were
honestly
made aware
doesn't
that
know.
Abumseli
He's not a knife
aggressively
thrower.
moved
He's a
towards
medical
Courtney at the
examiner.
time. She states she threw the knife, right?
That's the information that I have, yes.
You understand that a knife gains speed as it travels?
That I don't know.
Distance is important in a knife being thrown?
As a novice, that probably is correct, but
Woman, he
I want to say again, I'm not an expert in knife throwing.
Okay.
I am an expert in what knives do to people.
All right. But having said that, your opinion is that Courtney could not have thrown this knife, right?
As a hypothetical, the hypothetical that I was given, I said that what I see on the body is consistent with the person being stabbed. If I get other information that the person doing that had the knife is a knife thrower, that this is the type of knife that you could throw and it will go into a target, then I might have another opinion.
Well, you're saying knife thrower, but a person doesn't have to be an expert knife thrower to actually hit a target. Isn't that true?
That I don't know.
Have you seen there are millions of YouTube videos out there with people who are knife throwing and they're not experts?
I don't watch YouTube.
I don't watch YouTube.
Did you consult with a knife throwing expert?
No, I did not.
Did you do any research into knife throwing?
No, I did not.
Have you written any kind of articles or published anything regarding knife throwing?
No, I have not.
You agree that a person could generate a lot of power in a throw based on adrenaline? He's an expert, Judge.
In
Well,
medical
the government's opinion
examination.
is that she couldn't have thrown it, so we should be able to rebut that opinion by asking him questions about it. They put that into evidence.
Not sorry, medical examination. The hearing we're
So,
watching
sir, you
tomorrow,
cannot say that
there
Courtney
will be
Clenney
an
did not throw
expert
this
knife
knife.
thrower.
That's correct.
And your autopsy was performed on April 4th, and I know the toxicology was signed off on May 2nd. Is that correct?
Yes.
When did you speak to the state attorney's office and let them know what your opinion was? If you recall.
I spoke to someone in the state attorney's office in June of this year, end of June, I believe, or the week before.
Okay, so before June though, was there anything more to your report other than after May 2nd when you signed off on the toxicology? Anything else you needed to perform to close out your portion of the case?
No.
Okay, so as of May 2nd, you had your opinion. On the end of June, you spoke to the state attorney's office?
Yes.
Okay, and the charges here were filed, you're aware, in the middle of August?
I don't know.
Okay, may I have a moment? Sir, all your testimony, your conclusions, they're all documented in your report, is that correct?
In the autopsy report,
Yes, you've documented all of your conclusions in your report.
I documented the autopsy in the report,
Okay.
yes.
I noticed that there's nowhere in your report that says your opinion on the hypothetical was that the knife couldn't have been thrown. Is that something that would go into a report?
No, it would not.
It would not. And there's no reason for you to file any kind of supplemental report in
That's
this
correct.
case? Okay,
This report has cause of death. The death certificate has cause and manner of death. If you have other, a death that is a justified homicide or not justified, that's a legal thing. I just know the cause of death is stab wound of right subclavian artery. The manner of death is homicide.
understood. Thank you, sir, for your time.
Yes, this is briefly.
Dr. Hutchins, the defendant gave a statement in this case, and if she was to tell you this hypothetical was posed to you that she's 10 feet away, so roughly as far as I am from you, and she used the word flung the knife, and you weren't provided any further information that she was a knife throwing expert, is it your opinion that she could not throw that knife?
She said you flung it.
Flung it.
I would say that that is not something that could have happened given the injury that this person has.
No further question, Judge. From the city, yes.
Yes.
Nothing from the state.
Nothing from the defense.
The state's gonna rest.
Yes, Your Honor.
Yes, Judge. Your Honor, we are still doing the pretrial detention at the same time, so I'll address both. So Judge, the burden for the state is proof evident. The presumption is great that the defendant committed this crime. That is all evidence and all inferences created by that evidence is to be viewed in the light most favorable to the state. So when you hear the evidence from the ME, he says that her story doesn't match, that it doesn't scientifically work. The difference is that when she gives that statement, she's lying and she's not telling the truth. And that is the inference that now is put in favor of the state. When the other inference, when the state puts forward evidence that she's on the phone with her mom when the incident takes place, and then we put forward the mother's statement that doesn't include any of the events that the mother should have heard. The inference is the mother is lying when she speaks to police and is withholding information. The inference from that is that she's trying to assist her daughter. So in the light most favorable to the state has moved a number of items of evidence before Your Honor that shows that this defendant has committed this crime. And obviously the pretrial detention motion, it's a substantial probability, it's a lower burden. So if we are meeting Arthur, then we are meeting the substantial probability. And I want to go a little bit through some of the things of the defendant's statement. First and foremost, I need to inform the court that the victim is an authorized guest. The lease documents show that the victim was put on the lease documents as an authorized guest. He was never evicted or properly kicked out by the defendant, and certainly so to use such force of this manner to try and take someone or kick someone out would be illegal. In regards to her statement specifically, it confirms that at the very least we are eliminating that this is a suicide. We're eliminating that the cause of death is anything more than at the hands of this defendant. In regards to the argument, we get our motive. And that, I'm gonna tie that into really a lot of the Williams rule evidence that came before Your Honor in this case. The first, and in this case, is you hear from the mother that she hears the defendant yell, "You're lying, get out." And that is consistent with a lot of the situations that the state put before Your Honor. So Your Honor, in July 27th, that's the Vegas situation. That is specifically showing, and that event took place, which is documented inside of the report before Your Honor. The defendant is mad because he doesn't go to bed with her that night. When you talk and you move forward to the October 9th through the 11th situation, where there's the stab wound to the leg, that he's beaten with the phone to the front and back of the head, her only reason was, and she writes it in a text message, "It's because you're pissing me TF off." The January 30th, 2022 through February 1st, which is the slice to the face, and you have the text messages about enjoy the hospital. That talking about her, him gaslighting her, not answering her text messages, and she specifically says, I have to continue to explain to you how to act. We move to the February 21st, and that's the surveillance footage that shows nothing more than the victim trying to use the fob to assist her to go wherever she wants to go, and she resorts to violence, hitting him in the head, pulling his hair. The March 5th situation, which is the top over here, where he confirms to her, Courtney, but you hit me. The defendant's response is, shut the fuck up, bitch. Don't fucking say that shit. And that's because she doesn't want anyone else to hear the actions that she's doing. She doesn't want anyone to know because she doesn't want to get arrested. That's the inference. You move to March 23rd, and those are the recordings that Your Honor allowed in for this hearing's purposes. Specific statements, Your Honor, to read them, you a fucking cunt ass N-word bitch. Shut up and let me fucking slap you, dumbass. And you're an N-word. And why do those happen? The March 23rd, it's because he said hi to another girl that she happened to be on FaceTime with. And so it's another situation of jealousy and not doing what she wants. So what we have is a nature of this relationship is whenever this defendant isn't happy with how Mr. Ompluselli is acting, she resorts to violence. She resorts to screaming, she resorts to yelling, and the same thing happened on this day. So we sit here today, when we hear her statement, we get the confirmation that the same scenario is happening from the mother. The mother is talking to the detective and says, I hear yelling through the phone. I don't hear any threats, but I hear them yelling. I don't hear any violence, but I hear yelling. And she hears both of them yelling. So you get the same type of scenario where the defendant is saying, you lied. And you get the same sort of motive where she's going to act and keep acting upon it. In this situation, in her statement specifically, she talks about, and she references him as definitely the victim. She used the word exactly, he's definitely the victim. And that's at 3234 in that statement. And then she talks about how there's this whole scenario where she's choked up against the wall, that she can't breathe. And she makes it a very big point in that first time she says it to bring up 2, 3, 4 times that she cannot breathe. Now, when she goes through the story again, she doesn't mention it once. And that's an inconsistency. And that's the reality, is because it didn't happen. So when she said she's then brought down to the ground, and these are all during these times, at the point in time where she's now brought down to the ground and she changes this, she says she now changes it from grasping at her neck and holding her to where she can't breathe, it's an open hand. So that's an inconsistency. She then talks about how after this apparent attack, she's able to get away, get her phone, and talk to her mom. What's interesting about that is she then immediately goes and sits next to where the defendant is. How does that make sense? This person who apparently just choked you, attacked you, you're gonna now just...
I said the pretty ones usually are crazy. It's pretty privilege. They think that they can get whatever they want because of their looks. And then I said that he's talking about how she went from saying he choked her to then he just held her against the wall with an open hand. And her attorney said that he did it with his arm, not his hand, because I guess she didn't have finger marks on her neck. So now the story changes to it was an arm to her neck. So, and the story's changed from wall to floor, then back to wall. It's bizarre. The story is just evolving to different things. And that is usually because it's not true.
Sit next to him. You're not going to call 911. You're not going to try to leave the apartment. No, you're going to just sit next to him. So she's sitting next to him and she's talking about, and this is where you heard the statement from the mother where he's following her around and they're yelling at each other. When we talk about this whole point in time where she's on the phone, the defendant says this angered the victim. And at that point in time, he's trying to grab the phone from her, so she grabs the knife. What she makes very apparent is her location. She says, so in the photographs that Your Honor has, it shows the knife at.
I don't mind pausing to talk. I'm just afraid, like, I don't know when I'm going to pause and then it's going to crash StreamYard.
The corner edge of this kitchen. She would have to travel close to 8 feet to get to where the refrigerator is, which she says she's in front of the refrigerator, which would mean she would be traveling back to where the victim is. Again, that doesn't make sense unless you're coming to attack somebody.
Well, when she's got all the makeup and all the false stuff on, she is. But when she's just Courtney, she's not really. And also, we've seen her at her worst too, so that kind of takes away. Because it's not, you know, like when you know that a person's like a bad person, even if you thought they were pretty before and you get to know them, it's like, oh, they're not pretty anymore to you. You know what I mean? It's like you see them for who they are instead of seeing like the outward appearance. You know, like the first appearance illusion of that person is gone because you know how they really are. So all you see is ugly when they might be pretty on the outside. So, but I think she's pretty when she's all, you know, made up and everything. I think she's pretty. But like without all the makeup and everything, she's just average looking.
She talks about that, you know, he's running at her, and then she changes her words multiple times in that first statement. First she says he's running, then he's charging, and then he's aggressively walking. And for her sake, thank goodness the detective stopped her, because she would have kept going down and changing how fast he was coming at her. So at that point in time, she goes to explain exactly what her actions are with this knife, and she talks about it. And the detective talks first about how far away, and they try to talk about in regards to the room, and they come to this conclusion that it's, you know, it's not 20 feet, but it's definitely more than 10 feet away. And so she talks about, he asks her to describe how she threw this knife, and he's trying to give her any out at this point, where he's saying over the head, and she goes, no, I flung it, and she uses the word herself, flung. She flung this knife. There's nothing in that recording that talks about her having any sort of specialized knife training or knowing how to throw knives, and the amount of force that she could have created is nowhere near possible. And you heard that from the medical examiner, and that's as consistent as can be. The reality is, if given more information, perhaps his opinion changes, but for what's before him, based on her statement, based on who she is, she could not have thrown that knife. So what do we have? We have a stab wound, and that's the medical examiner's opinion. It's a stab wound, and as a result of that stab wound, the victim is dead. And so the state has put forward that not only has she committed this crime, but it's not self-defense, because we've put forward the evidence that contradicts her claims of self-defense, that shows her to be a liar, and to show that she's acting consistent with her nature in this relationship.
Oh, Brian, you don't know? Okay. He was her boyfriend and they were living together, and they got in a fight and they broke up, but then they made up and he moved back in. So this is like the day that he moved back in. They got in an argument. I don't know. Oh, I think I do remember what it was. He went to Subway to get them food, and I guess they had some type of tracking thing on their phones, like a find my location thing on their phones, and it wasn't active because they had been fighting. And I guess she thought I don't know. She got mad at him because she couldn't find him, and I guess she thought it was taking him too long to get food from Subway. So he came home and they had a fight. And she said that he choked her and threw her up on the wall, then threw her down on the floor, then back onto the wall. I mean, it was like I said, her story was inconsistent. Well, I don't know exactly what he did to her, but anyways, she got away from him. Like I said, she should have just left and gone for help or grabbed her phone and left and called 911. But no, she got a knife and flung it at him, is what she said. Those are her words. And it severed his subclavian artery. Now, well, I know, Brian, you know, your subclavian artery is under your clavicle. How do you fling a knife and sever someone's subclavian artery? And so he bled to death. Now, and listen to this. When she called 911, you can hear him in the background saying, I can't feel my arms. How long did she wait to call 911 that he had bled out enough that he couldn't feel his arms? She was, if you look at the thumbnail, those pants she's wearing that look red, that's his blood. She was covered in his blood because she pulled the knife out and cradled him while he bled out. I think she just stabbed him.
But most importantly, Judge, she makes this final sort of conclusory statement saying, you know, there's no bigger red flag. She has now just told the detective self-defense and gave this whole spiel of what happened, and then says it doesn't make sense, that it's not justified. So, judges, all of this case has shown that, you know, the victim is dead. That is certain. And
that is the dumbest thing to say in a police interview I have ever heard. I don't even know if it was justified. Dumb.
That she did it. And the only evidence before Your Honor in regards to self-defense is her statement.
She did.
Which has been riddled with mother statement by the medical examiner herself. So, Judge, when you talk about the facts that are before you, there's no doubt, let alone proof evident presumption great, that the defendant committed this crime. And certainly there's a substantial probability.
May it please the court, good afternoon. State. Judge, a brief apology.
Yeah, I already gave the don't pull out the impaled object speech. That must have been when you were on the phone. And the defense attorney asked the ME if he could have accidentally pushed the knife in farther, which he could have. But that he could have, whether it was a stab or thrown, but I don't think she could have thrown it and got it to even stick.
Receiving information that the state was calling witnesses. So the presentation that we have prepared is lengthy, but we will speed through this. took the time to go through all of this, and we're just going to highlight some things, but where we can, we will make it more brief. Thank you, Judge. The hearing is the highest burden that we have in any system, civil or criminal. Proof evident presumption, great, higher than beyond a reasonable doubt. It is the highest standard. The court is very aware of these things and has all the case law that we would cite to that. The state judge has failed to present proof evident presumption, great, for second degree murder. Not only that, because this kind of is a mixed hearing, they have also failed to present proof of substantial likelihood that second degree murder is the appropriate charge in this case. In order to prove second degree murder, Obam Sully is dead. We stipulate to that. The death was caused by the criminal act of Courtney Clenney. That's a disagreement that it was a criminal act. There's evidence of self-defense here to rebut any of the state's evidence. And the unlawful killing, again, if it's self-defense, it is unlawful. One of the biggest hurdles the state has here is to talk about how that's defined in the case law. Just the definition of what an imminently dangerous act is, the depraved mind portion, which the state fails miserably on, is that this was done with ill will, hatred, spite, or evil intent. The evidence taken in the light most favorable to the state shows that this occurred by Ms. Clenney defending her life when there was a physical altercation taking place. We know that. The neighbors called, everyone knows it was an argument that took place. This is not the type of offense that second degree murder is the appropriate charge. Again, justifiable use of deadly force. The appearance of the danger must have been so real that a danger could be avoided only through the use of that force. Clenney must have actually believed that danger was real. How do we know that Ms. Clenney knew that danger was real? It's even in her own statement. And what the state just highlighted, that she's like, I don't know if it's justified. What they leave out, and that's really what the state's case here is, mischaracterizing things and leaving things out, not giving the full picture to this court. At the end of that statement, she says, she's like, all I know was I was scared. The 911 call, you can see her frantic, trying to get help. That eliminates the ill will that the state has to prove in this case. Again, reasonable grounds to believe she was in danger of death. The difference of the physical stature of this individual, who's outweighed her by 50 pounds, was a lot taller, physically fit. This gentleman could wreak havoc on her had he chose to. Let's talk, the misrepresentations that I'm talking about came out during a lot of the testimony of the detective, so I'll kind of speak through this. But to highlight, the video, the elevator video, again, the way this elevator video was presented to the media for the state attorney's press conference by the state, she's not holding the door for him. She was panicking to get that door shut. It's clear. And what does Uncle Sully do? He blocks her out like a basketball player. At some point, puts her in a headlock. See, he's able to access the panel as he pushes her around. And then at the next slide, I believe, is when he's taunting her. You can visibly see him taunting her. That's the type of individual this was. And he's laughing.
And Judge, objection, that's not happening.
The video, I know you're on TV. Video. Again, the insinuation that Miss Deborah Clenney, her mother, is trying to have her put forth some type of self-defense. They put that in the warrant, not
It was going so good. Why? No, I have a generator. So when the power goes out, I still have internet because the internet that I have now, they have a generator. So during power outages, I still have internet. But when I get the new internet, it's going to be through my power company. So when they're down, they're down. So even with a generator, I won't have internet. That's the only downside. What I did the other day, I just checked availability, and then they got back to me and said to send an email to set up an appointment for them to come out. And I didn't do that because I wanted to talk to Travis first. And Travis says it's all good. So I'm going to call them today to make an appointment for them to come out. So that's the only negative that I see in this, is that during hurricanes, and the average amount of time is usually 3 days. And that's going to suck if there's a trial and I'm streaming a trial. So that's the only downside. And it sucks, but it's only 3 days a year. So do I want to have internet problems every day of every year, or just 3 days a year? So I'd rather have more speed at $15 less a month. Okay, this is almost over. Let's see if we can do this. Okay, I'm going to turn my camera off again because it works better without the camera on.
So whether they were there before, there's additional bruising that was not provided to me.
I don't know why it won't load. Come on, StreamYard. There we go.
Lead detective's investigation is the statements by the neighbors. These are independent witnesses who saw blood in the elevator, was told, again, this is like, I think, double hearsay, but was told by a resident that Omum punched her, Courtney, in the face. That same witness, JS, Again, JS, looks like the neighbor said, whenever she was by herself, happy, smiling, would say hi. When Omum present, quiet, looked down, didn't have any conversations. Again, evidence of the abuse that she suffered, which Mr. Clenney knew very early on when this relationship got toxic. Again, another neighbor, EP, same thing. He said there was a weird vibe in the elevator. Clearly something was amiss in this relationship. Again, independent evidence of a toxic relationship. This neighbor also talks about the event in the dog park where Omuseli aggressively grabbed Courtney by the tricep.
She got Baker acted? Hang on. Oh, it muted me. Tomorrow there's another hearing that happened. This was a couple months ago where they did actually test throwing knives at a pig. I'm trying to get this one done today so we can do that one tomorrow. But StreamYard hates me. I don't know why it hates me now. It didn't hate me 2 weeks ago, 3 weeks ago, whenever I was doing trials and stuff, and Sarah Boone documents and all the other stuff I've been doing. And now it started hating me last week.
Courts reviewed these. A lot of these bruises speak for themselves. Courtney's plea for help, again. Okay, just to have judge, again, this is so clear, she's trying to get a restraining order. She testifies as to, had he been violent in the past? She says yes, and the officer.
Okay, hold up. Pork, cabbage, and potatoes. That's a new one. That is not one. That is not one that I've heard about. In the South, where are you, Judy? Ohio? Because in the South, we do collard greens, or any kind of greens, actually, for the greens are supposed to bring you money, and then we do black-eyed peas. That's supposed to bring you good luck. But I don't like greens. I love black-eyed peas, but I don't like greens. But I've never heard the pork, cabbage, and potatoes. Are they supposed to bring good luck or certain stuff? Or is that just a traditional New Year's meal where you come from? Ohio. Yeah, that's what I thought. So, is there a reason behind it or just a New Year's meal tradition? Oh, and Nancy, you're in Ohio too, right? Oh, no. We literally live in the middle of nowhere. There's a prison there and a dairy there, and like one residence there and one residence here. I mean, there's other houses, but they're like, they have internet too, but they work for the dairy, and I guess they're here like on a green card or whatever because they're from Mexico, and they rotate in and out and in and out all the time. I don't know. I mean, I guess they could have family that's visiting just because they're from Mexico doesn't mean that they don't have family that might want to visit them. There's another New Year's Day thing that I didn't know about. I'm not superstitious at all. Um, but this one I observe now because one day I went to my friend's house on New Year's Day, and oh, potato equals growth, cabbage equals wealth, and pork equals luck. Oh, now that one I could do because I like all of those things. But there's another one that you're not supposed to wash clothes on New Year's Day because that means you're washing clothes for a funeral. Someone in your family is going to die. And that year. And I never heard that before. Massachusetts. Is that where you're from, Nancy? But you live in Ohio? I thought you lived in Ohio. Why did I think you lived in Ohio? Oh, that could be true. They might be trying to get in touch with their family in Mexico. I never heard of that either. Whoa. I'm hearing all kinds of stuff I never heard of before. So I went to my friends on New Year's Day and they were like, what'd you do today? I was like, I just washed clothes. That's all I did today. And they're like, no, you're not supposed to do that. And I'm like, what? Why? Because someone in your family's going to die. I was like, what? Well, I had an indoor outdoor cat that on New Year's Eve, and it was 2000. And I worked 3 to 11 shift, and she had we stayed up till midnight, me and the cat. And I was like, we did it, Tasha, we did it. It's a new century, we did it. And she was like getting all excited and up in my face, because cats, they feed off of your energy, right? And then I went out to my car to get something, and she followed me out, and she didn't want to come back inside. I was like, okay, you can stay out here. And usually, she goes out and plays outside, and then she'll just, when someone goes out and opens the door, she'll come back in. Or I could go out and call her and she would come in. She was that kind of a cat. And I couldn't find her. And I was like, well, oh, Massachusetts. Okay, I don't know why I thought you were in Ohio. So she didn't come home. She didn't come home all the next day. So then when I went to my friend's house, they're like, no, you're not supposed to wash clothes. And then my dad found her on the 2nd, and she was dead. Something had killed her outside. That's why she never came home. So I'm not superstitious, but I do not wash clothes on New Year's Day in memory of my cat Tasha that died. I'm not superstitious. I'm not. I just don't wash clothes because my cat died. Because I washed clothes on New Year's Day. But yeah, I've never heard. Why do you leave the door open at midnight? Where did that go? Who said that? Judy. You leave your front door open at midnight? Aww. That's sad. So you just put a silver dollar in your hand and then wash your hands with it in your hands? I don't know if we have any silver dollars. But I'm not superstitious though. Okay, let's get this done.
Officers kind of just they brush right past that instead of saying, hey, why don't you tell us about that abuse? She does.
Okay, go back big. Big. Now it's gonna.
What the state doesn't tell you is at the beginning of the body worn camera is that this security officer tells them, hey, my people went upstairs and there's Detective Omunselli didn't say anything until she realized, wait, I'm getting arrested. Officer, I didn't tell you everything that happened. Well, you can, I'll supplement my report, but you're going to jail. That's the video. I'm sure Your Honor saw the condition of Mr. Omunselli on that video in the morning. And you could see how Courtney's interaction was with the detective. The state failed to provide Your Honor this information.
The female calls while she's calling security, she's basically saying, like, get your hands off me. You get up there, They both at one point admit to physical altercation inside of the room from upstairs. Okay. I think there's a alleged careful in the term. Oh, careful. Careful, right? The guy is saying that didn't happen. So, I just walked by and he's like throwing over the trash can, so I have no idea what their deal is. So I think they're both wrong.
Again, that officer says both people admitted to getting physical. Courtney ends up going to jail for that. This is the end of the video. Where it talks about it. I'm not telling you everything.
Okay, there's a lot of I didn't say because I didn't want you to get in trouble.
Again, protecting her abuser so that he doesn't get in trouble. The text messages, the state has tried to make a case about what these text messages show. Again, these are text messages. They're lacking in context, they're lacking in tone, they're lacking in expression. This is the state's case, substantial likelihood. Again, what's important about these text messages are, after there's some discussion about some incidents, what always happens is Courtney says to Owamseli, go ahead and tell them what happened because then I will say what really happened. I'm not afraid. She was not afraid to say what would happen if he called the police. And those are what these text messages show. Clearly, Judge, we're not denying this was a toxic relationship. Mr. Clenney knew it. Miss Clenney knew it. Everybody except for Courtney and Mr. Owamseli. He says, I'm not saying anything because tell them your side and I'll tell them what happened. And he never says anything because he's afraid of the truth because the truth would hurt. The state tries to say that Courtney is acting, I think that what the state's trying to prove by some of the text messages was like, oh, that she's acting in ill will by her use of certain things. Again, these are text messages without context. She mentions too, without getting into the details, but in her interview, I know your Honor's looked at it, she talks about Christian, I believe, was holding a knife to himself in the bathroom. He committing self-harm.
I don't remember exactly what the situation was, but he had taken a knife, he grabbed it from my face, and then I got scared, and he was kind of waving at me, but he wasn't for me, and then he took it to the extra room and closed the door, and he had a self-harm, so I told him, okay, well, I'm going to change him. Regardless of whether or not what's going on. And I opened the door, and he was open the door, so I got really scared that he was doing something that I couldn't control, so I called cops. And he wasn't there talking to me about that, but I was really scared. And he tried to do it many times, but I don't know where he was right then. So you know, bipolar.
We know, again, the nature of the relationship. It's described by Courtney, and in the context of this, we know that Courtney, when she describes this attack, clearly had no other choice but to defend herself. She talks about seeing the whites of his eyes. and her level of fear.
It was in like in college. Like we were obviously it was a big deal. So then I was like, all right, to work and came home and came over and we were standing by on the couch, before the kitchen, I was in the kitchen. And then all my inside was like coming at me. And so I grabbed one of these knives from the Christmas and grabbed one and I was like, I swear to God. I swear to God. Yeah, but it's just like, I was like, don't come in, we're supposed to, because I mean, earlier, I haven't really had that good fucking breathe, I'm sorry, I couldn't breathe, and it's very scary, and I just like that kind of thing, like, you know, he's okay. If you're choking and angry enough, you might like, I mean, this is different, I think, but if you like choking or like hitting yourself, I can't breathe, you might go slow. So I grabbed my knife, I said, don't come any closer to me. I absolutely no intention of using it. I was all my mom, and he's coming at me like he's gonna grab me with a photo of the knife or something, and so I was just like, I was like, don't any closer.
Now, what's important here, the state, talks about, I flung it. The detective in this case couldn't remember a lot of things. Your Honor can evaluate his testimony, but what's important, especially in this type of case, would be, hey, you know what? Let's talk about how you flung that knife. Did you throw it? Did you wind up? He never goes to have her describe that. Really fails to have her go through, because that would have been something that probably should have been done. Show me again, how did you throw the knife? He goes through the statement with her 3 times and never goes and does follow-up. But again, Your Honor has gone through the full statement. It is not, the detective said, asked a couple of times. Sometimes people will remember more detail when you go through it again. And that's what her statement is. It's not inconsistent at all. Again, at the end, when she says, he asked her if this is justified, which obviously is a legal conclusion, but at the end, which the state again leaves out, is when she says,
I do not think that this was. I don't know. I really don't know. It's justified. Because I know.
Judge, the evidence that the state's own evidence provided to the defense discovery casts doubt in substantial respects as to, number one, proof evidence presumption great, substantial likelihood, proof beyond a reasonable doubt clearly. The state's case and the State versus Perry, I provided that to the court, they have failed here, Judge, to put forth sufficient evidence for second-degree murder. Again, the Seymour versus State case, 132 Southern 3rd, 300, the language in there is very important for this case. Facts would support something other than a guilty verdict on second-degree murder charge, then the proof is not evident presumption great. Judge, that's exactly what we have here. Again, even if this is not a case of self-defense, although it is, the case law is clear. Extreme recklessness or an impulsive overreaction to an attack or injury is in itself insufficient to support a second-degree murder conviction. That's what we have here. There's no, clearly, under the case law, there's no proof evident presumption great. An impulsive overreaction to an attack. Let's say this wasn't self-defense. Let's say she shouldn't have thrown the knife. An overreaction to Munselli's impending attack, finishing off what he started earlier by choking her. An impulsive overreaction to an attack or injury is insufficient to prove what's an essential element of second-degree murder. It's insufficient to prove ill will, hatred, or spite. and it is well supported by case law by all the district courts in this state. Again, even if her conduct is reckless, let's assume again she wasn't defending her life that night, which she was. Extreme reckless behavior in itself is not enough to infer malice. Again, no ill will, hatred, spite, or evil intent. Well supported by case law, the state has failed to present sufficient evidence for second-degree murder in this case. Again, even if we're talking about a jury, which that would only be beyond a reasonable doubt standard, and they were to reject the self-defense, again, impulsive overreaction to such an attack does not warrant a conviction for manslaughter, warrants a conviction for manslaughter, not second-degree murder. And I believe that was an appellate decision that overturned the conviction and directed the trial court to enter a guilty verdict to manslaughter, reducing the charge. There was a lot to do yesterday, and I know the court asked for some clarification about the timing of these phone calls this last night and dissect the reports that we supplemented, Your Honor, today. Now, this is very, very important, Judge. This is the cutout section, okay, from the state's own fund records, the cell phone records from Courtney's phone. And what we have here are the two phone calls at the top to Mom, which, by the way, in Mom's statement to the detective, I'll get to that in a minute. These are the first two phone calls. This is the time of those phone calls, okay? The first call to Courtney to her mother, the top one, is at 4:43 p.m. That call lasts 393 seconds converted to minutes, 6 minutes, 30 seconds. If you add that to the call start time, that brings you to 4:49. That's Miami time. I converted this number to Miami. So what do we know? The second phone call starts at 4:49. So that's a hang up and a redial immediately. So there are two phone calls, which, by the way, Ms. Clenney told that to the lead detective in her interview. So we have those two phone calls. Now we know that, so that takes us, if you add that 430 seconds, the second phone call, that brings us to at least 4:56, possibly 4:57, because it only has the start time in minutes. So we don't know the seconds. So for example, this start time of 20:43, which is at 4:43, could have been 20:43 and 59 seconds. So there is some type of gap here that we don't know. But what we do know, when you add the amount of seconds, you get to simultaneous consecutive phone calls being placed by Courtney to her mother. Now, what we know is, based on the report by the security staff at One Paraiso, at approximately 4:50 p.m., this the front desk person, who's Marvin Durant, the front desk personnel, right, calls security, who's Miss Ormeal, okay, who writes this report. Mr. Durant called the police at 4:44, while myself, Miss Ormeal, and Danny, another person that works here, went up to the unit. They knocked several times. No one answers the door, but we could hear them yelling and screaming at each other. So we know at 4:50, and however long it took them to get upstairs, Mr. Olamselli's still arguing with Courtney. Then we have Miss Orville state, but we could hear them yelling and screaming at each other. I then dispatched the front desk to call the unit. She gets on the radio, calls the front desk and says, hey, call the unit. Call the occupants of the apartment. So we now know at that phone call, right? We know Courtney's on the phone with her mother. We know 786-472-8232, no answer. Calls Courtney's phone at 20:53, which is 4:53 p.m. These calls were not answered. So we know that at 4:53, okay, So what we know, Judge, at 4:53 is when that call to the front desk is made by security who's standing outside the door. So we do know at 4:53 p.m., they're still arguing. So at 4:58 p.m., they both decided to go back to the unit in which Courtney Clenney finally opened the door. I'll just let you guys talk. You let me know when you guys are done. Thank you. At 4:58, they go back up to the unit. And what do we know? Based on the phone call to 911, at 4:57, Courtney called 911. So we believe the evidence shows that Courtney called 911 immediately. After the incident. But with certainty, based on these objective records by independent witnesses and phone records, what we do know is that the incident had to have occurred between 4:53 p.m. and 4:57 p.m. when she called 911. The state tries to insinuate that this occurred during the first call to Courtney's mother and that she let him bleed out. And that's contrary to the state's own evidence, Judge. There's a 3-minute window here or 4-minute window here at best. At best, in the light most favorable to the state. And it's irresponsible to say otherwise.
So we went in the unit 2201. We knocked on the door, nobody answered the door. We didn't hear nothing. So they were talking. Once we were knocking at the door, they stopped. They stopped. We don't hear nothing. They were talking. They were like cursing, like we were talking. So I said, okay.
So that is the verbal statement that corroborates her written report that she made to the lead detective in this case, talking about when things occurred and that she could hear them arguing. And then when the knock came, they stopped. And that's when she called the front desk, dispatched the front desk to make those calls, which show up on the phone records.
Yeah, once we're knocking at the door,
Okay.
and then I said, Danny, so he's like, you have to open the door, okay. We went and checked on the next door at 22. This is 2201 that happened. So we went on the 2202
Okay.
to ask them question. They didn't answer the door. So I'm like, can you, I radio called the front desk to call 2202 to ask them question. 2202 did not respond. So I'm like, okay, Danny, this time let's go back to the unit at the time paramedic is on the way. So let's just go back to the unit to make sure they're all right. So when we went back, that's when she walked to me, the lady, or white lady, she walked to me fully with blood. She was like, I did up. And then I'm like, what happened? Everything's up.
So when they go up to the apartment again at 4:58, Courtney comes out having already called 911 at 4:57, comes out seeking the assistance of security, screaming, covered in blood, begging for help, like she did on the 911 phone call. Again, eliminates ill will, hatred, malice, which the state has to prove for second-degree murder. Under any standard, they failed.
She told me that she was on the phone with you when part of this incident was going down.
Yes, she was.
So around what time was it that you guys were on the phone?
I looked on my records a little bit ago, so let me look back and see exactly what time that was. Let's see. Okay, it looks like she called me at first at 3:43 and we talked till about 2 different phone calls talked to about 356. That's what it looks like, but I'm not 100% sure.
Again, Judge, the state tries to tell you that Ms. Clenney is lying to protect her daughter about the one phone call. Didn't say anything about two. She tells the detective two phone calls, and she gives the exact start time and the exact end time that corresponds exactly to the phone records we have. There's nothing untruthful or deceptive by Deborah Clenney in this case. She again describes what she heard. Again, talking about the detective in this case, he never followed up with her about telling her what else did you hear?
I heard her say, "You lied, just get out, just go away." I'd actually been out there for 6 days trying to get rid of it.
You lied what?
She was saying, "You're lying," and he was saying, "I'm not lying," but I really don't know what the whole thing was about. I didn't know he was there. I thought he was gone.
Again, after I arrived at the Homicide Bureau, doesn't follow up even after the Clenneys offered to make additional statements.
So, in the argument that you overheard today on the phone, was he, or was it just like a regular, like, normal, volume voice, or?
He was screaming at her.
Yeah.
Because I told her to tell him to stop screaming.
Yeah.
And so, no, he was screaming at her, and she was so unbelieved that he was screaming. I couldn't hear what he was saying. I could hear her talking over good. And then the next thing I know, she's called, crying, yelling for me to get out. I don't know how he did. She didn't tell me that part.
Okay.
She told her to get out. She yelled, "You lied." And he was yelling at her back. And actually, he was screaming because I thought that, security, I didn't think police, security was looking at me called from the yelling. And the dogs were barking as they did when Christian started.
So we do know that Ms. Clenney did describe what was occurring to the detective. And again, he got interrupted by my arrival at the Homicide Bureau. But what we also know is that during the course of the conversation with Ms. Clenney, you could hear Mr. Clenney in the background. The state made a whole to-do about, he was on the phone and he wouldn't have wanted him on the phone. No, at no time does the detective say, "You know what, Ms. Clenney, I need to talk to you privately, so could you have your husband get off the line?" You could hear Courtney's dad in the background while Detective Briseño's interviewing her. And then when he goes down to get me at the Homicide Bureau, you can hear Mr. Clenney, Ms. Clenney talking the entire time. And Detective Jerez is in the room listening to them, recording their conversation. So she knows that Mr. Clenney's present. Mr. Clenney tells the detective, the attorney's there. He's like, "I'm happy to answer your questions, but the attorney's there if he says so." And then Kim Clenney says, "And we're happy to visit with you if you want." So the state's saying that this is some kind of them not being forthright and disclosing everything that they know at the time is just disingenuous.
Well,
Thanks for you.
okay.
And we're happy to visit with you. It's just he's there. He's looking as long as he was.
Again, what I said earlier, you can hear them talking. Play that clip.
So pretty much just go to, pretty much she called him around approximately 3:43 to like 3:56 p.m. And pretty much you overheard him and her talking. You lied, and he was arguing back. I'm not lying.
Actually, the main thing she was saying was get out, leave, go away. That was actually, she did say you lied, but the main thing she was really trying to say is get out of here, go away.
Yeah.
And you would not leave. And that's exactly, this is Kim Clay's father. That's exactly the same.
Now, what's important here is obviously, Mr. Clenney gets to the statement in its entirety. Detective Briseno never goes back to ask more follow-ups. At that point, he terminates the interview. And so he knew Kim Clenney was there. They knew that. And for the state to mischaracterize this evidence, again, disingenuous. Now, Judge, I said, at best, if we look at the facts of this case in the light most favorable to the state, at best, this is a manslaughter charge. This is a self-defense case. Courtney was in a struggle for her life. But if that offense, which has a $25,000 scheduled bond actually assigned to it, to prove manslaughter, the state would have to prove Mr. Umbraselli's dead. Courtney intentionally committed an act or act that caused the death of Umbraselli, which would be the throwing of the knife. Clenney intentionally procured the act that caused the death, or the death was caused by culpable negligence of Clenney. At best, in the light most favorable to the state, again, the standard for an Arthur, but even under pretrial detention, at best, this is a manslaughter case, which is a bondable offense, which is why this court should grant a bond. The Menini case is very, I think, I believe this was a habeas petition filed by Menini, that it may well be that a jury could conclude that Menini acted without justification and is in fact guilty as charged. Again, that's what the court could find here, or a jury could find here, if it wasn't a case of self-defense. But on the other hand, the facts as presented to the circuit court are also susceptible of interpretations ranging from a lesser degree of murder down to excusable homicide, which is what we have here. Again, habeas petition taken up to the 2nd District, which then directed the trial court to issue a bond. Judge, I will, for the rest of the evidence, since Ms. Puglisi addressed the second phase kind of with Mr. Clenney, I'd let her conclude our summary of the presentation.
Judge, I didn't know if you wanted, wait, did the state even?
I do want to hear both phase arguments today. Did you have anything else?
Yes, sir. Also, Judge, I don't know when you want to hear from the next Kim's attorney, but Mr. Hansfield is also here, so.
You guys make a statement.
Judge, I'll wait till after they finish and then I'll make the statement.
The defense brings up this idea of no ill will, but the reality is ill will in all that case law really talks and point to the desire to injure. And that's exactly what we have here. We have this situation where defense wants to bring up this self-defense and this idea, and they bring up the mother's statement, the timeline of the 911, but there are facts that they're misleading this court. For one, when they talk about the 911, when they talk about the 911 calls and the call log in general, when they say NA means not answered, that's not actually true. Because Your Honor has a key, and that's specifically going to talk to the connection type. It has nothing to do with whether someone answered, actually the amount of time that shows up. So if a call goes for longer than 5 seconds, the call was answered. There's multiple calls on there that are less than that, that go up to 18 seconds. 18 seconds is gonna mean that she answered that call. And so that's exactly what that is. So when defense tells you NA says not answered, that's incorrect. When we talk about the 911 call, when we talk about the timing, if Your Honor wants to take the mother's statement as true about her being on the phone until 4:56, and then Ms. Clenney calling at 4:57, what that means is she's on the phone while the stabbing occurs. And what that means is she did not give that information to the detective. So she's misleading this, she is misleading the detective in whether or not the information she knows is true or not. In regards to that statement specifically, there's a number of different things that are important, Judge. And that would be that what she didn't do and what Ms. Clenney didn't do. So she tells this court, or she tells in the statement that the defendant's telling the victim to get out that he lied, to leave and go away. But what that would also indicate is that the defendant never told her mother that she was grabbed by the neck, that she was slammed on the ground. Because as a mother, the first thing you're going to do when a detective tells you what happened, what did you hear, is my daughter was being beaten up, abused. Didn't happen. Why? Because the defendant never told her mother that. When we talk about the description and the amount of time that goes through from those calls, you have a situation where there's more than enough time. There's 14 minutes that go by from the point in time that the defendant is on the phone with her mother, that this situation occurred, that she doesn't call 911. Not only that, but based on her own statement, she would have been on the call for this occurrence. She doesn't call 911, which is another indication that the mother is also trying to support her daughter and defend her daughter in this situation. The defense brings up, and they showed a number of photos of bruising. And their assertion is that these bruises occurred during this incident. What they didn't show you, Your Honor, were any bruises of the victim's, the defendant's neck. Because if the defendant was held by her neck to the point that she could not breathe, that she was then put on the ground and held on the ground by her neck, there would also be bruises of that. And yet, none of those are before Your Honor because they don't exist, which also now contradict again the defendant's statement. And Your Honor, the testimony is clear. The medical examiner made it very apparent that unless there's some sort of information before him that this defendant is a knife throwing expert, she would not have been able to throw this knife to where it went 3 inches into his chest, and that led to his artery being severed. So we stand here with a number of items of evidence that contradict this claim of self-defense. That and the fact of her history of showing that she is the aggressive one in this relationship. Self-proclaimed. In her own statement, she says she's the aggressive one in her relationship. It just doesn't make any sense. There's no way that she would have been able to throw this knife and have it land into his chest to the point of the depth that it did, and with the amount of force to break through the skin. And there's no evidence that contradicts what the medical examiner has come here and said before, Your Honor. So, Judge, at the end of the day, the defendant is caught up with her back up against the wall. She has a situation where she has acted out as she's shown consistent with the nature of the relationship. She stabbed the victim. He's dying. He's bleeding. She doesn't know what to do. She's on the phone with her mother trying to figure out what to do. And that's consistently shown that she's trying to plan and figure out what to do. Finally, she calls 911. And at that point in time, when she's brought down to the police department, the mother's text messages indicate to her and allege self-defense. And innocent people are found guilty all the time. You don't text that unless you know what happened in that room, unless you heard what happened, unless your daughter told you he's been stabbed, that I stabbed him. That's why you bring up self-defense. She doesn't mention any of that, though, when the detective is there. And so that's the reality, is she's hoping that her daughter has her phone so that she's going to hear that, see that, and not give the statement that you put before Your Honor. That doesn't make sense. So, Your Honor, we've brought forward the evidence that we have. We've shown that she is inconsistent with her story. She's been contradicted by numerous witnesses, including her own mother, that the bruises that defense has brought to you, they don't make sense. So at this point in time, Judge, there's no other reason to know what happened in that room other than that this is the defendant acting out and consistent with what she's done in the past, that she didn't like something that Mr. Amcoselli did. And from the victim's mother's own words, lying, she wanted him out. And when he was trying to defend himself, to have some conversation with her, she stabbed him. So we are here, Judge, because the defendant has committed a second-degree murder. She stabbed him, the victim is dead, she's shown ill will, hatred, and spite, and as a result of her actions, it's not a justified killing. So at this point, Judge, we believe we have met our burden, not only for Arthur, but also under pretrial detention. Thank you.
Defense, and again, Mr. Bill, since you're not one of the parties to the case, I will definitely allow you to give a statement. It doesn't have any evidentiary value, but I know that,
Thank you, Judge. I mean, obviously in State versus Arthur, Your Honor, once you make a decision, even if you find proof evident presumption great, the court still can grant a bond. There are various factors that Your Honor would need to look to. And specifically with respect to the Florida statute, 907.041 pretrial detention, it talks about pretrial detention and the various factors or circumstances that the court should look to. Specifically here in this case, the state is moving forward on subsection C1 that the defendant has previously violated conditions of release and that no further condition of release are reasonably likely to assure the defendant's presence at subsequent proceedings. And subsection 5, which says that the defendant poses the threat of harm to the community, the court may so conclude if it finds that the defendant is presently charged with a dangerous crime, which we do concede that second-degree murder, even manslaughter, is considered a dangerous crime pursuant to the statute, that there is a substantial probability that the defendant committed such crime, which we disagree with, that the factual circumstances of the crime indicated disregard for the safety of the community, and that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. And that's where really this dangerousness comes into play, which is that there's no conditions of release to protect the community. And based on 907.046, the purpose of and criteria for bail determination, there are the normal circumstances, the nature and circumstances of the offense charged, the weight of the evidence against the defendant, which obviously you heard a whole hearing and have evidence on. The defendant's family ties, length of residence in the community, employment history, financial resources, and mental condition, past and present conduct. Then it goes on to other factors like the source of funds used to post the bail, whether the defendant is already on release pending resolution of another criminal proceeding, the nature and probability of intimidation and danger to the victims, whether there's a probable cause to believe the defendant committed a new crime, pretrial release. With respect, there's no evidence that there would be any intimidation or danger to Abu Sali's family or anything like that. And with respect to committing a new crime while on pretrial release, I don't believe there's any evidence to support that. But going specifically, Judge, to why Courtney is not a flight risk. First of all, I understand she does not have ties to this community, the South Florida community, but she does have ties to the United States, born and raised. She was raised in Texas. She obviously, as you know, is very close to her parents, who are both here today, Deborah and Kim. She has a sister. She has many aunts, uncles, cousins. She has grandparents, and they all live in the Texas community. So she has strong ties to there. As far as aware of the pending investigation, this is really important because unlike many murder cases that we see, usually they arrest the defendant right on the date of the incident, right? In here, actually what we have is she met with the police, she gave a full statement to them, and then they released her. And she remained out on release up until her arrest while she was in a rehabilitation program in Hawaii towards the end of August. And for over 4.5 months approximately. And she was aware of that investigation. Obviously, she had an attorney. She was in constant contact with him. If she wanted to flee, Judge, she could have at any time. She knew she had an investigation for a murder charge. She already knew she had actually stabbed Mr. Abramzelli. So there was no question that if she felt fear, she could have fled at that time. And that's where the financial status comes in. It's important. The reason we put Mr. Clenney on today was for the court to understand she did not have over $2 million. She does not have a substantial amount of money. She did. All that money has been spent. One, creating more ties to this country, right? If she was going to flee, why would she pay $335,000 to the IRS? Why would she purchase a home and pay another almost $380,000? She could have taken that cash, $11,000 or so in her name as far as cash goes, and she could have already left. She could have already spent that. Participation in a treatment program. Your Honor can consider mental health and should in this case. There's no question that she needs treatment, not just for the PTSD, but as you heard, there's allegations, and I don't think it's really allegations. She had a alcohol and substance abuse problem, and that is Vegas, where they said they were both drunk. She needs treatment, and she knows it, and she knew it while she was out pending this investigation. In fact, she went initially to a outpatient program. She realized that wasn't good enough. It wasn't helping her. She was still drinking very heavily. And so she signed up to go to an inpatient program, which she got COVID and she couldn't go to. And then she looked into the program in Hawaii and was there for about 8 days before the marshals came to arrest her. But she knows she needs treatment. She still wants that treatment. We have looked into it, Your Honor. We were able to provide you with a letter from Emerge. It's a outpatient treatment program in Texas. She did attend that outpatient treatment program before, but they determined it was not sufficient. She needed inpatient, but they are willing to take her again. And so she would, as part of a condition of the bond, we would be saying that the judge should put, Your Honor, should put a condition that she does attend outpatient treatment program as required or as recommended by the program. We know that this was the letter, and you have this, Your Honor. It's the letter from the exclusive, which was the program that she attended in Hawaii. And what we know is that during that time while she was there, she was diagnosed with PTSD, alcohol use disorder severe, and cocaine use disorder severe. But despite all that, she was making great progress before she was removed by the U.S. Marshals. There's no question of her following rules or regulations. Obviously, I think the DUI warrant, we have to discuss it. It's probably the most important thing because Your Honor should consider whether somebody is not somebody who can appear in court, and whether they have failed to appear in court before is something that you need to look to. And in this case, she does have a warrant out of Texas for a DUI. Now, that is not because she failed to appear, though, honestly, Judge. What happened, as you saw from the affidavit we provided from her attorney in Texas, Mr. Anthus, is that she actually did appear in court on the day she was going to take a plea. And unfortunately, she was under the influence at that time. And the attorney advised her that you cannot take a knowingly and voluntarily plea when you're under the influence. The judge will take you into custody. What you really need is an inpatient program. It was her decision to leave, which she did. a warrant was issued. But immediately following that, Judge, she did go representate her in 2015 for her other DUI, which are the only two cases that she has criminal history for, where she has convictions. And back then also, she maintained constant contact. One of the things the state talks about is her fleeing. They use that word in their pleadings, that she fled the jurisdiction. First of all, she did not flee Miami. She has really no ties here, right? She moved here with Albucelli, but she has no family here, being here by herself. She went back to Austin, Texas to be near her family. That's not fleeing. She was in contact with her attorney, who was also in contact with the state attorney's office, and they were aware that she was in Texas. She likewise did not flee the jurisdiction in Texas to go to any of these, to California or Las Vegas. There are no court orders that precluded her from traveling. The state has not provided any court orders. They just say, it says that she was required to do so. And in both of these cases, he said it was not a violation of Ms. Clenney's bond for her to leave the jurisdiction. Now, one thing I just want to advise the court is she has been offered a plea by the state attorney's office in Texas. It is a plea to time served on that misdemeanor DUI case. She signed the plea and abstention documents the other day when we were in court here on Tuesday. She has court there on November 28th. At that time, the warrant will be vacated and the plea will be entered and that case will be closed. Courtney is not a danger to the community. Type of crime alone is not a reason to deny the bond. And again, the state puts in various cases, but as Your Honor knows, they were dismissed. The two convictions she has are for DUIs, and we agree she needs treatment, and sending her to a program requiring that will ensure that she does not drink, and that can also be a condition that she does not drink throughout the bond. We know this was a tumultuous relationship, but this was a relationship between two individuals. Your Honor has to look to see if she'd be a danger or harm to the safety of the community. There's no evidence that she would be a danger. If released, she'd be a danger to the rest of the community. This is really a one, it was based on a one relationship and that's it. And the length of delay to the charge is very important, Judge, because it's tough for the state to say that she's such a danger and harm to the community when they let her remain on a bond for, or not bond, sorry, pending investigation for 4.5 months. And I know it's easy to say, well, their investigation wasn't complete. Maybe they can say that, but the medical examiner had his opinion already. And he said it wasn't self-defense, and that was concluded back in May. And if somebody is truly dangerous, you don't leave them out on the streets. You put that case to the top of the pile and you work on it and you get it done. You don't leave that person out. They could not have felt that she was that much months. There are conditions of release that could reasonably sufficient to protect the community in this case. A monetary bond, her parents would be the one that would be paying this bond, Judge. We have a bondsman, Mr. Valenza from 305 Bail Bonds is here, and he has spoken to the parents. He has an understanding of collateral and everything that would be involved, and he is willing to accept the bond in this case. Home confinement with GPS monitoring, we do think that that would be the best way for the court to ensure with permission to attend program. She should only be at home, going to treatment and going back home. Judge, because we're asking that she be released and be allowed to return to do house arrest with her parents at their home, we understand. I spoke to house arrest, home confinement here in Miami, and they can only be monitoring cases in the Southern District. And so I found a private program. It's called EPS Monitoring Company, and what they do is they use the same kind of GPS trackers that other programs do. It is a program that the defense would have to pay the costs of that supervision, but it is similar to what we have. It's a GPS, it's a bracelet, it goes on your ankle, and they monitor everywhere they go. What they advised is they get told what the court wants. So if the court says she's only allowed to be gone from her home from such and such time to such and such time for her program, that's what they will do. They will also, law enforcement and judges can have individualized scheduled updates on the offender status. They can give you weekly updates, Judge, if you'd like, on what she's doing. They can give it to the state. What they said was that if she violates, if the court wants, the court would be the first one to know, but they keep track of all of that. So, Judge, just in conclusion, I want to say that there's no question this was a very toxic, tumultuous relationship. But the activity or the involvement of law enforcement in this case, I would really describe it in one word as dismissive. Because she gave a statement on April 3rd, and what we know is that she had visible markings on her body. And the detective at no time asked her, can you please tell me about those markings? She says she was choked on 3 occasions, one being that night, and the detective didn't ask her the details about those other 2 occasions. We know from Las Vegas that she talked about protecting her offender, and we know from all cases of domestic violence, there's so many out there that the women protect their abusers. It is not uncommon. Everybody knows it. And that is very clear from the evidence here of where she said she was trying to protect him. And those text messages saying, I will tell them what really happened. And then we go to 2 days before this incident where the police are called. And once again, they asked her, has he ever been physical with you? And she says, well, yes, but that's not my concern. Once again, she's protecting her abuser. But what the police should have done is they should have said, hey, we're trying to help you. Have that compassion.
And Judge, I'm going to direct us to phase 2 argument, the relevance of what the police should have done.
They didn't do that. And you know what, Judge? We could see her fear in that video when she asks for help. And she was so brave that she told the police that day that she was scared of him. But like so many people, she took him back the very next day. And this is what we see, what she tells the police in her statement. So it was definitely 2 nights ago. He explained the whole thing, and I was like, okay, you know what, you will never gaslight me again. And those were the 2 main things. And this was very late at night. So the last couple of days have been, he was just great. He was happy to be back in the apartment. I was happy to have him back at the apartment because I missed him. and because been waking up telling me good morning, I love you, touching me like it's just, I felt very, very loved when I woke up this morning before. I am so heartbroken. It's just like, why? Because he did not keep his promise and she had to defend herself. And so, Judge, we are asking not only from phase one that the state has not met its burden, but now in phase two, we would say that there absolutely is no evidence that she would be a harm to the community and that there are reasonable conditions of bond that could be set. Upon release, Mr. Prieto and I would pick her up, personally take custody of her, fly her to Texas to get the bracelet monitor put on her ankle and take her to her parents' home so that we ensure that she does get safely to the house and she's there. So we ask the court to grant a bond in this case.
Yes. So Judge, the question is whether she's a flight risk to the danger community. Concede she has no communal ties here to Miami-Dade County. They've conceded that this court cannot monitor her with any systems that we use here in Miami-Dade County. This court would have no control over any sort of system that would be in place over in Texas. It would have no control if the defendant decided to cut off her monitor and flee. It would have no control if the defendant's family decided to assist her in trying to leave the jurisdiction. The defendant has the not only means, but the ability to make money in a conventional job. Her job, all she needs is an internet connection. And so the situation would be that if she decided to, and there's no evidence before this court about the financial means of her parents, and certainly there's a number of dollars that the records aren't corroborating. There's a significant amount of money that's still outstanding based on what has been spent. But the defendant has the means to not only charter a private jet, but also to continue her work in another country. So the OnlyFans company is not a United States-based company. And so not only does this court not have jurisdiction over it, but the federal government would not have jurisdiction over it. In regards to violating her release conditions, she's violated not only in Texas, but also the Vegas arrests. So, Your Honor, she has not only a 2015 DUI Texas arrest, she then has the disorderly intoxication and paraphernalia possession out of California arrest. Then we move over to 2020, where you get her second DUI arrest in Texas, which then has the Vegas domestic violence battery violating it, which was in 2021. And now we have this case. So, Judge, she's shown that not only is she continuously picking up these offenses, but she's also violating the release of those cases before they're handled. The defense came up here and has told you, they've gone through the process of trying to close out those matters, but that doesn't change the fact that there's a current warrant for her arrest for skipping town and taking years to try and handle that DUI out of Texas. She's found in Hawaii in a drug rehab facility. They weren't able to find anything apparently closer to their home. And certainly this is a situation where if she wanted to, she could leave just like she did for that. They talk about the fact that this was a long investigation. And Your Honor should take no credence to that argument. The reality is investigations take time. Has nothing to do as to her flight risk or her danger to the community. But what does matter to the danger of the community are prior incidents of domestic violence, including the one that was entered into evidence today, where she was a child that involved her mother and her sister. So there are certain situations where even when she's with her family, she has shown that she is violent, and that not only is the community not safe, she's not safe, and her family would not be safe. So the fact that she has this huge alcohol problem as well as drug problem, there's no guarantee that she's able to beat this, to get on top of this. Anytime she has some sort of relapse, if she were to be out, these types of situations continue to happen in her life. And she's shown that this is what continues to happen. So, Your Honor, we put forward to you everything that she's done, not only to Christian, but also that she's shown throughout her life in interacting with her family. It shows that there are no reasonable means of to ensure not only the safety of the community, but also that she will appear in this court. If Your Honor were to release her, there's no guarantee she's coming back. So it means that this court could find, other than holding the defendant no bond in this instance, and this goes to the same argument that if Your Honor does find that that perhaps the state has not met its burden of proof evident presumption great as to second-degree murder, defense ceding this idea of manslaughter, Your Honor can still hold her no bond as a danger to the community under the substantial probability under pretrial detention, because manslaughter does fall within the dangerous crime statute, and she, under the same category, this phase 2 argument, you can ensure her presence before this court as well as the danger to the community. So for those reasons, the state would request that Your Honor continue to hold her, that Your Honor find that the state has met its burden of proof evident presumption great as to the charged crime, and that Your Honor continues to hold it. Thank you.
Thank you very much for the opportunity to address the court regarding this very sad occasion on behalf of the Ambaselli family, some of which you are appearing by way of Zoom. This nightmare, their life was shaken on April 3rd. The reason I was then engaged, set up a meeting with the state attorney's office, and to unfold correctly. And the first thing I did was apologize as an officer of this court, as a lawyer in this community, as a former prosecutor, knowing that that's not the way we do things here in Miami-Dade County. I was embarrassed. And then they learned I believe, unfortunately, in this case, we too often assume, because we know about females being in an abusive relation, but we don't realize that men also find themselves in abusive relations. Mr. Umbaselli is dead today because of the toxic relationship, and that he was in denial of being physically abused as well as mentally abused. Let me give an example, just what I mean by the physical and mental abuse that he endured as it relates to this case. He was referred often as the N-word. That still didn't stop him because of the love he had for her. The story that is being painted is that the defendant was the victim of violence, mental. But listen to her words as presented in the record on behalf of the defendant. Come here, let me slap you. Those are the words from the defendant to Mr. Umbaselli. Is that the language of someone who's afraid for their life? Someone who's a victim of abuse? Absolutely not. That is the language of someone who is controlling. Let's look at other words. I hope you enjoy your stay in the hospital. That was just one of the second times that she had used physical force, where he had to go to the hospital. And how do we know that he was the victim of abusive relation? When he went to the hospital, he didn't tell him who was responsible for why he was at the hospital, even though he was cut up in his face.
Your Honor, I'm just going to object. Mr. Hanfield is an amazing attorney. We all know his reputation in the community, but he's here in the role of a victim advocate. He's not here to comment on the strength of the evidence, the strength of the state's case. That's a legal argument that the state attorney had their opportunity to address. And he's talking about the weight of evidence and what the evidence shows, which I think I went against him when I was a prosecutor, and he tooled me around the courtroom several times. But I think it's improper, so I'd object.
Obviously, none of the training rules that I have to make evidentiary value, because I can't, weigh it when it comes to, the state's burden or the defense's burden. Under Marcy's law, the victim has the right to be heard at substantive proceedings. I agree, though, that, the analysis of the weight of the evidence probably not, maybe not as much of the role of the victim's advocate, but I'm gonna let you, I'm still gonna let you speak, but I do agree that maybe, under the singular portion of Marcy's law that allows them to be heard during these circumstances, it goes less to legal argument and more to the victim's point of view, but I do still want to hear from you, but I think the answer is so much legal argument.
And Judge, I'm going to connect it all at the end. That's why I want the court to have an understanding as to what my client family has had to endure. They believe the privilege of a bond. Why? First of all, she has already demonstrated that she doesn't respect the law. There are 3 cases when I was in LA myself with my investigator. I sent him to the courthouse just to check to see. And sure enough, we discovered, for which was provided to the state, there was an outstanding warrant for the defendant's arrest since 2015.
Judge,
A
I
case-
objecting to this. This goes completely to legal argument, not representing the victim's voice to be heard under Washington.
So I have
What it shows, Judge, is this. If I imagine for one moment that it was Mr. Ambaselli, the defendant, and God forbid, Ms. Courtney Clenney, the deceased. It is no way in heaven's name I can even imagine any. And that is based upon a pattern. And the reason why there's been so much clear that there is a different benefit that she has received that most people don't receive. The Ambaselli family, that their loved one and that family and this defendant to receive equal treatment under the law looks at the fact that when this incident happened, I have not heard the state nor the defendant indicate the point. The first person, I'm sitting here, and the first person after a person has been stabbed was not 911 call. You got someone dying. There is there was nothing, there's no junket.
Objection, it's just going above and beyond.
I actually objection to allow this last time.
This system is blind justice. Everyone should be treated equally. Whether the deceased is a male or whether if the deceased was vice versa being the defendant. She left, she lives in Texas. She was apprehended in Hawaii. The defense has indicated that she is now willing, we in 2022, so some 7 years later, are going to try to resolve an outstanding
reasons for the promotions. And we can get the transcript soon, but, the message is going to be Thanksgiving, so I know that might be reason for the
December 8th, dude? December 8th. Yeah, December 8th. Thursday.
Okay, that's it. I guess she did not give them her decision right then, but as far as I know, she is still in custody. So it was denied. And they did mention a hearing on December 8th. And I think that is the one that I'm going to do tomorrow. I don't know, because there was one that I had planned to do, and then I couldn't find it. And then Judy was like in there, and then she was like, she texted me and she's like, what happened? It says the video's not available. And I said, I canceled it because I can't find it anywhere. Well, Spike, quit getting under my feet and you won't get kicked, honey. I'm sorry. Oh, that dog loves me. Lay down right there. Lay down right there. You're out of the range of my feet, right there. He's too chubby for me to pick up, or I would pick him up and show him to you. He's super cute. Nope, he's back under my feet again. It would be. It absolutely would be. I can't believe they even asked for that. Like I said, I would be okay if she was under house arrest in Miami. And their point was she only needs an internet connection to work. But her dad said they canceled her account. They won't let her work anymore. But what's wrong with her working? Because she'll make money that she can use to flee? Is that why it's not good for her to work? If they have her on a GPS tether, then they'll know if she flees or tries to flee. I don't know. So they did this other hearing. I think it was sometime in December. I don't know. It might not have been the one in December. There's so many hearings. There's one that's really short, and there's one that's it's like 26 minutes, and there's another one that's like an hour and something. But there is one. This is the one I'm going to do tomorrow. I don't remember how long it is. There's a medical examiner in it. It's not that medical examiner. It's another medical examiner. And he is an amateur knife thrower, and he has a video of a professional knife thrower throwing knives at a pig. I don't know what the outcome is. I don't know the purpose of the hearing unless it's to show that it's possible to throw a knife and get it to penetrate. So, I don't know. But that's the one that I'm going to do tomorrow. I've not watched these. I had watched, but I was modding at the time. And when you mod for a channel, you're more focused on the chat than you are the actual hearing. So when I'm doing them, I can pay more attention to the actual hearing. 10 o'clock, as usual. Because I have found that, and also when I go to YouTube Studio, it tells me when my subscribers are on most of the time. And 10 o'clock seems like a really good time. Now, when I do trials, like live stuff that start at 8 and 9 o'clock, I have no choice. I mean, I could start late, but 10 o'clock seems to be a good time. If I stream in the evenings, you guys don't show up, or you show up like way later when I'm like ending my stream. So, but 10 o'clock seems to be a good time. And this one's not as long. So the sound is crap on it though. So we're going to have to rely on the closed captions. And unless they can come out today and switch the internet, I'm probably going to have to do it without the camera on again. So, oh, you have to work tomorrow, Nancy? Wait, you'll be home by the 10 o'clock in the morning? Where do you have to go that early in the morning? I used to have to get up at 5 to be at work at 7. I'm so glad I'm retired. Yeah, so the sound is not good on this one. I don't know why, because the sound was pretty good on that one, and it's the same courtroom. So, oh, you have an appointment. Okay. So, I guess that's it. And I will see you guys tomorrow at 10 o'clock. And we're going to have to deal with bad audio, and crappy StreamYard again. So I'll see you guys tomorrow. Bye. Thanks for coming.